Yes.
I beg to mention for listing of one third methodology, that Sonic school methodology.
Next week, next Tuesday. Next Tuesday. Tuesday. It was fixed on a date. I was not here. Okay. 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 Yes. Ma'am. Your matter has not come. Aaj hi 2 bazaar aani ke. 2 bazaar le aao. 2 o'clock. Yes, madam.
Item number 16 may be taken at 2 p.m.
Item number 16. Okay. 16 2 p.m.
PM.
Yes, Mr.
May it please your lordship. Item number 56.
Yes.
Well, may I pray after 4 weeks? In fact, two things have happened. We have to take steps for getting the new incumbent on record, number one.
Okay.
And
On
number
the
two,
prayer of
exercise
Mr. S.
review
Bani,
application.
the order has not been complied with till date.
But there was change in government.
On the prayer of Mr. S. Bani, learned counsel for the petitioner, raised it to list this matter again after 4 weeks on a date to effect, right? 56, huh?
I'm grateful.
May I please your lordship? I beg to mention item number 40. I have taken consent from the petitioner. I am appearing for 8 and 9. Lordship, I need 2 weeks time to file our affidavit in opposition. Item 40.
You're not there?
I am here, Arthur.
Ms. R. Kakoti, respondent, learned counsel for the respondent number 8 and 9, submits a praise that she be granted 4 weeks time to bring on record the affidavit on behalf of the said respondent. The prayer is not objected to by the learned counsel for the petitioner. Registry accordingly to list this matters again after 4 weeks on a date to be fixed by it.
May I please your lordship? Your lordship, with the consent of the other side, I beg to mention item number 11. So I pray for adjournment due to learned and case counsel's final favor. He's suffering from final favor due to illness. So I pray for adjournment for 2 weeks.
Who? For?
And alarm. Respondent of 5.
You be here. We'll hear the petitioner. You be here. We'll hear the petitioner. We'll hear the petitioner.
Yes.
You be here.
You have taken the consent for the other side.
No problem. Be here.
My lord. Therefore, listing notice.
Listing before the senior court. Court number 13, I suppose.
Maybe Rashid. I beg to mention item number 9, my lord. My lord, the youngest counsel for the petitioner has expired, my lord.
No problem. We will handle it.
My lord, I'm for the respondent number.
We'll
5.
handle it. We'll handle it. Let it
Basically,
come.
Yes, my lord.
It's a transfer order of 2018. What is left here?
Nothing.
And there was no stay order, nothing.
It has become infructuous.
We will say now you will, this matter will dispose of, directing them to, if required, a fresh order of transfer by following the procedure
The
guidelines.
date may, the date may fix that.
Today.
We have to
Today.
file up the instruction, my lord.
No need. We can't help it. When did the council die?
Actually, 2020.
Then 4 years, no instruction, another instruction. We'll handle it. Don't worry.
I informed you, my lord.
You will handle it. Don't worry. You be here when the matter is called up. You are in the case.
Yes, my lord.
Then you be here.
I was junior.
Yeah, what is there?
I'm not.
You are now 4 years senior. You have experience of another 4 years now.
Yes, my lord.
So read the brief and be here. I'll help you. Don't worry. Be here. Mr. Khan, we have allowed your dispose of your writ petition. I have dictated the order. We have disposed it off, saying that within 3 months they will accommodate you against a regular vacant post of section assistant and your entire service from 93, because you are getting the scale of pay. So there is no problem. Entire service would be treated for all your future service benefits, fixation of pay, pension, etc.
I'm grateful, Your Lordship.
You will get it by tomorrow.
Top of the list, item 69.
ये तो dispose the खैरी बोले.
My lord, the area is very narrow, but I'm trying to convince this honorable court. My lord, the matter pertains to my lord.
No, it is. The Habibur Rahman. 69. It will give you. Order no steps.
Top of the list.
Or top of the list. So, hobo. What yeah? 16. Oh. Yes.
Yes, my lord, the limited grounds, my lord. My lord, kindly see for a moment page 25, my lord.
Page 25 of the writ petition.
Grouping of it.
Okay.
My lord, may I read the contents?
Hmm.
My lord, there other issues are also involved there.
You cannot. You have not done a departmental proceeding against him.
Quite right, my lord.
You have acted towards dismissing him only on the conviction.
Yes, my lord.
Once that conviction goes, any action taken
My lord.
goes.
My lord, kindly see.
You have retired.
My lord, yes, my lord.
You have retired.
Now,
To
lordship,
your
kindly-
peril.
Lordship, kindly see that in this case, there are three issues are there, lordship, for kind consideration.
You just show me the order
Yes, my
for
lord,
which he was.
yes, ma'am. This order itself, so there are two cases, my lord. This order itself says there are two
Okay.
cases.
Show me. Page,
The management of the Assam
page,
State
page,
Court-
page.
Page 25, my lord.
Hmm.
The management of Assam State Corporation filed a criminal case bearing number 325 in the Court of Chief Judicial Magistrate Kamrup at Guwahati for misappropriation of rupees 71 lakhs 91,264 against Mohammed Habibur Rahman, field assistant so-and-so in charge of Morigaon Cell Point under the Assam State Corporation. However, a case bearing special case number 91/8/2003 was also registered in the Court of Special Judge Assam against the Mohammed Habibur Rahman, and as a result of which complaint case number 325/2002 was 2000.
Okay, forget it. We have read it. Here,
That is-
the only contention is that you were convicted in a criminal case,
Yes,
and accordingly, you are a bad man. There is no stay of the conviction. So, following Rule 10 of
Yes,
the
sir.
Assam Disciplinary Appeal Rules, you have been terminated.
Lord, the second point is also important.
What is the second?
My lord, my in affidavit, my lord.
Oh, okay.
My lord, it is a case where, my lord, he has lost his trust to the.
That is not available to you until and unless you don't draw up a
My lord,
department.
I'm coming, my lord.
Ah.
Lordship, kindly see, there is also a civil case pending against him where.
You do it, you recover. Who
Exactly, my lord.
can a civil case be a ground for his conviction?
My lord,
Can a civil case
yes,
be a ground for his dismissal? Show me the law.
my lord, yes, my lord. One citation I would like to say.
Show me.
My lord, only one citation I would like to relate upon. Involved therewith. Straightway, my lord, I'm coming to paragraph 11, my lord, for a moment. There is a reference of case, Ajit Kumar Nath. In our judgment, the law is fairly well settled. Acquittal by criminal court would not debar an employer.
Where?
Paragraph 11, my lord.
Paragraph?
11, my lord. Fourth page. Paragraph 11. In our judgment, the law is fairly well settled. Acquittal by criminal court would not debar an employer from exercising power in accordance with the rules and
Who
regulations.
is disputing this position? We are not disputing this
Exactly,
position.
my lord. Now,
You
in the
draw
next-
up if you had drawn up a departmental proceeding against him, we would have been with you.
my lord,
You have
right.
not done that.
Now, lordship, another point is that, my lord, case to case basis are factual
I'm
aspects are
sorry,
different.
it cannot be.
Now, only,
Because if your termination is on basis of Rule 10,
my lord,
conviction goes,
Yes.
everything goes
yes, ma'am. That is true, my lord. Lordship, only one, I would like only one paragraph, my lord, rely upon.
of this judgment.
Paragraph 20, my lord.
Paragraph?
20. Loss of confidence, my lord. This is also one of the ground, my lord.
For that, you will have to draw up a departmental proceeding against him. On air, you can't.
No, quite right, my lord.
Then?
My lord, thing is that, my lord, the situation
And
demands.
I'll put a word in the, put a paragraph in the order that the officers responsible for this should also be proceeded against.
A little, my lord, that observation will help us. My lord.
I'll do that.
My lord, question that, my lord, only one thing is that the 77 lakhs rupees which ought to be.
You have instituted a civil case against
No,
him.
that has
Money
been filed. Education is going on.
Go
In
ahead.
spite of that, my lord, that amount could not be recovered. And on the other hand, suppose if you would like to pay that, my lord, wages or whatever, my lord, outstanding, my lord, kindly see the situation balance of, my lord.
That you cannot, because the conviction set aside by this court, whether on technical or otherwise,
My lord.
we cannot go into that. Rule 10 is very, very.
My lord. Now, only last ground, my
Hmm.
lordship, I would like to play. My lord, there is a possibility of appeal, which was not exhausted by the, my lord, read petitioner.
That we will not go into. That is not needed. When the foundation has been taken away, What is left? That's a futile exercise altogether.
It ought to have, approach to the concerned authority, madam.
That we will
That is
ignore.
bypass, madam.
16. Today, after 8 years, we'll ignore that. Anything more?
These are the things.
Yes, Mr. Counsel.
Lordship, as far as regards his contention regarding loss of consciousness, my lord. My lord, in the review audit report.
Haven't you heard what I had said?
My lord.
Why are you behind that again? Okay, give me the dates. The dates you have given me.
Termination date, madam.
No, the order of termination.
25, madam. Page 25.
25, 9. No.
Yes. Dismissal from service. 26, operative part. Last paragraph.
And after the acquittal, what did you do? Did you consider his case?
My lord, no, we didn't consider his case after acquittal, my lord. There is a representation between, my lord, that he approached before this honorable court, madam.
And the civil case execution is on.
Yes, that is on, madam.
And when is your date of retirement?
My lord, I already retired and my lord, the petitioner. already-
On when?
Lordship, already told. I have to-
56 years.
My lord, his date of retirement is, madam, in the year 2000.
2000.
2019 is.
2022.
No.
madam.
What is the date? Can you get me the date of his retirement? Counsel,
Lordship, I'll get it.
just get that. When you get it, let's inform him. We'll call the matter.
Madam.
Just inform, we will take it up.
May I plead the lordship?
Hmm.
Lordship, I am appearing on behalf of D. Sharma. He has instructed me that if he doesn't arrive, then he requested me to appear on his behalf. And he
Yes,
stated that he will take steps today, except lordship. Just fix for order for not taking steps, lordship.
23 December order, you have not taken steps. You're not interested, why will we carry this file? We'll close it.
Lordship, today itself, steps will be taken, lordship. One chance may be given to me, lordship.
Who is appearing for the respondents? Health? Who is the counsel?
Please, I'm taking handy, lordship. I'm appearing on behalf
No.
of D. Sharma.
Jay Sharma.
D. Sharma.
Bishop. Call him. We'll consider. Yes, Mr. Upamanyu. This is BTC. No. Yes,
Lordship.
he is a disabled person,
Yes, lordship.
person with benchmark disability.
Lordship, Mr.
He was selected. But subsequently, that appointment was not made because they had found your benchmark disability to be more than what is prescribed, right?
Lordship, actually, in fact, I am not in the case, lordship.
Call the counsel.
Lordship. Yes, lordship.
Those cases we had dealt with, that review board you had constituted,
Yes, lordship.
it's the same matter. Just go through it. If it is that, we will dispose
SLR
it off.
matter.
No? Yes,
My lord, the other day.
Mr. Goswami.
Yes.
One assistance. In a workman compensation matter, there are two aspects. One is the delay that occasions and the compensation per se. Now, for the compensation, the insurance company is liable. Would the policy is there? Would the delay part also not come within that interest for penalty for delay also not come within that purview of that insurance policy? Why?
Because there is judgment of the Supreme Court.
Huh,
Penalty, payment of compensation is because of the one employer only.
huh,
Insurance company have to reimburse.
huh,
As per statutory period within the time, they have to pay the amount.
huh.
If that is not paid,
Huh.
that's the liability of the owner. In the policy condition, there is no liability to pay penalty. That is
That penalty component will not come in.
penalty. Interest-
Okay. Two, now, if the employee who has expired is an employee of the contractor, will the employer of the contractor be also liable? It's the contractor only who will be liable, right? No one else. Thank you. Yes, Mr.
I am appearing
Last
for
occasion,
respondent.
matter was raised before your lordship,
Hmm.
that we are the, not a principal employer. We have entrusted the contract.
You are the employer of the contractor.
The respondent five.
Yes, who is for respondent number 5?
Yes, my lord. I
Why?
am for
Pay that
respondent.
amount.
No, I have paid the amount, my lord.
But this
Yeah,
penalty.
yes. In their writ petition, they have. categorically stated-
No. You have paid the compensation through your insurer.
Yeah,
And the penalty?
penalty that has not been as per the judgment of the honorable.
Forget it. You are the employer. You are liable. You should have paid him. Why is the railways being saddled with that
No,
responsibility?
my lord, we have paid the insured, we are the.
I am
contractor.
on the penalty of 1,48,260. You have not presented a challenge to that.
No, it was Workman Compensation Code has directed the NS Railway to pay.
Why? Why the NF railway?
My lord, that is the judgment, my lord.
That's why he is on appeal. We are interfering. You pay now.
I am appealing for respondent number 2, 3, and 4.
Okay.
And-
You are to get the money. That's all. You are for ABCI.
Yes, yes.
You pay the money.
Lordship, I have paid the amount which is covered
Mr.
under.
Counsel, it's your employee who died.
Hmm.
Why should we saddle the railways with that?
No. Court. And it is-
No, they have, that judgment is an appeal before me.
Yes, your lordship.
I'll have to interfere with that.
Yes, your lordship. With all respect, lordship, they have, in spite of receipt of notice, NF Railway has not appeared.
Forget it. Default, can your responsibility be transferred to them? You pay this amount with interest.
Lordship, give me a time to,
2 o'clock. 2 o'clock.
At 2 o'clock, I have some.
You need not, you want the money, either from him or from him, you will get it. 2 o'clock. You show me how you are not responsible.
give me some date,
No,
your lordship.
today, at 6:14 matter, we are not adjourning it any further. Today at 2 o'clock. I did I went through. One clarification I required, Mr. Goswami has given me. He's an expert in that line. I've got it though. Mr. Goswami,
Lordship, AGCC has been closed down.
I know,
And
but
there is
the plea of yours may not be
No, Lordship,
sustainable
now,
because
Lordship, it has been already settled. This court has to settle the matter. And that
Supreme
is
Court also?
As per earlier notification, they are entitled.
they are entitled. So give them that. That we'll dispose of the petition. None is
Already
appearing.
SAP also filed. that
Has been dismissed. 159, our High Court's judgment, single judge, division bench, and then
SLP.
SLP. Where are those orders?
I think that has not been annexed here.
159 is not here. My Lord Justice Monojit Bhuya and
Now,
anyway.
thereafter, Lordship, another judgment has been passed by this honorable court, compliance of the honorable Supreme Court judgment, that already SLP has been dismissed. That is why writ appeal also dismissed.
writ appeal also dismissed. And the present writ appeal against which that was gone, for which this matter was not being,
Dismissed.
that is also dismissed. You have that writ appeal order. I have writ appeal order. Do you have?
Lordship. Already affidavit, it has been annexed, Lordship.
In the writ appeal order?
Writ appeal order, page 25. That will state ultimately was dismissed.
Okay.
Stay order is there, that is dismissed.
Uh, 159, I suppose, no?
Receipt number
159,
159.
okay.
Receipt number 159.
And no, against the order of passed in case of the petitioner hearing, an appeal was filed. What was that number?
Here is 159 or 15.
No, there is a common order. I got it somewhere. Yes. Madam, writ appeal 342, 2015. If you have a copy, will let us know. 15. We'll follow that order
Okay.
and then we'll close it.
They are entitled to early notification.
Earlier notification. 10/6/2004 notification. Within how many? 2 months? Whom will we direct? We'll have to direct the
First,
government
the
only.
government will pay the amount.
Hmm.
That is the industry.
Who is the authority?
Industry department will
Pay. We will, it's public enterprises.
public enterprise.
Public enterprises and finance, we'll make them both responsible. I'll pass the order when I get that out. Dispose of.
Item 4.
One is
All of
for
you should
non
do.
payment of salary.
What is the status of your service now? Are you serving?
But it from 2017.
Yes, madam.
Your Lordship, Mr. B. Gogoi appears for this matter. He's on legs in court for your
Call
letter
him.
time being. Right, Your Lordship.
After some time. Mr. Nayak, these matters have been resolved below 20 years.
Which one, Lordship?
The pension for PNRD employees, provincialized employees, earlier because if they did not have 20 years, they were not being paid pension. Then you took out a list of 354 people, 10 years.
Lordship.
Then there was a lot of number of people who were left out. Subsequently, I think the government has taken a decision. Yes, Council, what is the status?
In this case, strict directions will be issued to the principal secretary to verify the pension papers of the.
Why? You tell me your latest policy with regard to the entitlement of these people. There are judgments of this court also.
Our affidavit in opposition,
Your affidavit says that you have sent a proposal. What happened after this?
his name was not there in that.
In
list.
that original 354, that is gone.
That is gone, but
That is gone.
his name was not provided as.
No, that 354 is gone. Subsequently, you took a further decision, processing, for people who have crossed 10 years but not completed 20 years.
Less than 20.
Less than. What is that decision?
In that exercise, his petitioner's name was left out, We have conceded to a mistake over there.
You give me that decision. You have made the people who are having less than 20 years of service liable, eligible for pension. Huh? Where is that?
It is at page 4 of our affidavit in opposition filed by the joint director. 18 many pages. We provided the pensionary benefits to 354 number of provincialized pension.
I'm not on that. That is gone. But who, after that also you moved a list. You do one thing. You just call up your authorities, receive instructions as to the fate of the proposal of people who have completed more than 10 years and less than 20 years. Or you get hold of Mr. Islam, M. Islam, Mufidul Islam. Where is Mr. Islam is here, Mr. Talda? We'll have it at 2. Get hold of Mr. M. Islam. You have any instructions? No. Then get hold of Mr. M. Islam. He will have. There is a decision. Just get that, we'll dispose of it. Time being. Hey, am I here? Citizenship Act was laws and
mail due. The matter has come after 5.5 years challenging a dismissal because I was initially.
Now tell me,
Some instructions are required.
no instruction is required. No stay. There was no stay here.
There's no stay.
Then what is the error in that order? What is the error in that order of dismissal?
Dismissal, not to be, because of, I was declared initially a foreigner.
You were not. You were of that particular stream.
Stream.
And that particular stream person who is there, he is a foreigner per se.
Yes.
But he can register. You did not register. And accordingly, on the date, you were so appointed.
Yes.
No, ito na. Amar foreigners law kita person. On the day when you were appointed, you admittedly were you are a foreigner.
No, from 76, I am working in the department.
That's it. In the year 76, you are a foreigner because you became a citizen of India only after the orders passed by this court and your registration. Will that have a retrospective effect? It cannot have a retrospective effect.
On 99, the reference was made. 2004 order was passed by the tribunal.
You did not register. Your wife registered.
Yes, thereafter.
We are only on a small question whether on the date of your initial appointment, you were an Indian or not. You were admittedly not an Indian. If you are not an Indian citizen, you are not entitled to a post.
But I am.
Subsequent action will not remedy the earlier action.
But Lordship, I have got myself registered, except the right to vote, other rights.
Will it be retrospective? It will not be retrospective. Anything which has accrued to you before as a citizen before that, that will be gone. From that day, you are a citizen of India. We have no dispute on that. You will continue to be a citizen of India.
I'll just pray that from 1976, I have worked.
We can't help it. Because once it is found that you are not a citizen, we will not direct for any recovery, but the order is perfectly fine.
Lordship, I'll address, Lordship will fix another day on this point, but
2 o'clock.
Lordship, not today.
No, not today.
Lordship, some judgment.
18 matter, we are not carrying it.
Lordship,
I am convinced. If you want me to convince me, convince me. 2 o'clock. Only on that point. 76, whether you were an Indian citizen and the findings recorded is correct or not. You had yourself registered after the orders of this court. From that day, you will be an Indian citizen. See the rules, Act 6. It would nice. It could finals law. Oh. I'll get that book. You read that provision. Huh?
There is a provision that if I get registered.
Then from that day you become a citizen. But prior to that, you are a foreigner. Otherwise, your arrest would have been, your detention would have been illegal. Your detention has not been said to be illegal. Anyway. Examine.
Hello, I am appearing on behalf of SR Rabat. This is regarding termination of a.
You show me any material to counter the claim of the respondents that you are not colorblind. Anything?
I got they after 1 year they declared.
1 year, 2 year, be that as it may, you were in provision. That is why the provisions of Rule 5 of the Temporary Service Act was invoked. After that, what is that? No material I've gone through. You have even not prayed for a review medical board.
No relief can be made. Yeah.
Sorry. Only relief I can give you if you want to prepare. I'll take it up at 2 o'clock.
Madam, Mr. H. Gupta,
Oh, we don't want Mr. X. Gupta. No.
Because
I can't read this file again. I have read it. You just show me anything on record. One small factor here. that yes, because of this, this is bad. I will be with you. Otherwise, I don't find anything. You too, go through the file.
Mr. Gupta is out of station.
Let him be. We don't want him. Yes, Mr. Talukdar.
My lord.
After the interim directions, he is continuing. Anything you have found?
My lord, in fact, here the,
And what is this debarment?
my lord, in fact, what has happened, here the order at page 26 is challenged on the ground, my lord, that the register is without jurisdiction.
Forget it. Whatever it is, 18 order today, you have not even come up with an affidavit. You have not come up with an application for vacation. Why should we? We will make that absolute. We'll give you a liberty if there is something against you in a manner known to law, proceed against it.
That can be done, but my lord, I draw your lordship's attention to one provision. My lord, section 38.
What is it?
38 to, my lord, the power and function of the board. So, my lord, basically, this appointment, removal, etc. of the secretary, my lord, is done by the board. So, your lordship will close the writ petition, giving, my lord, the discretion.
That we will do. That
Yes,
we will do.
discretion to the board.
Okay.
To take, my lord, appropriate
But-
action.
Mr. M. Das, Learned Counsel for the petitioner, also heard Mr. S.K. Talukdar, Standing Counsel, Corporation Department, appearing for the respondents of number 1, 2, 3, and 4. None has entered appearance on behalf of the respondent number 5. The challenge in the present proceedings is to an order dated 12/11/2018. No, 9/11/2018, issued by the Register of Cooperative Societies, debarring the petitioner herein from functioning as the secretary of Bhattadrova Sotra SS Limited. That is at page 26, underline kar diya. Also, the petitioner also presents a challenge to an order dated 12/11/2018. 12/11 or 13/11? 12/11/2013, whereby directions were issued by the Assistant Register of Cooperative Societies, Nagaon, in pursuance to the said order dated 9/11/2018 to take immediate steps for making alternative arrangements for holding the post of secretary upon debarment of the petitioner from functioning in the said capacity. Also, the petitioner herein contends that he was appointed as the secretary of the Bhattadrova Sotra SS Limited, bracketed, herein after referred to as the society, bracket over, on by the board of the said society on 7/6/2013, and he was so functioning in the said capacity. Full stop. Subsequently, certain allegations came to be leveled against the petitioner, for which criminal proceedings came to be so instituted against him, and the petitioner had approached this court seeking bail in the said criminal case, and accordingly this court had also enlarged him on bail. Also, the respondent authorities wide and order dated. Respondent authorities, more particularly the Register of Cooperative Societies, Assam, Khanapara, Assam, wide and order dated 9/11/2018, noticing the criminal case as instituted against the petitioner and the nature of allegations as leveled against him, proceeded to exercise power under section 29, bracketed 4 of the Assam Cooperative Societies Act 2004, and the petitioner herein was debarred from discharging the duties of Secretary Bhattadrova Sotra of the society, of the said society. Also, the said order was followed by an communication dated 13/11/2018, 12/11/2018, by which the Assistant Register of Cooperative Societies, Nagaon, had required the board, the society, to make alternative arrangements for holding the post of secretary on account of the debarment of the petitioner herein. Also, the respondent authorities herein have also The said writ petition on being instituted and moved before this court, this court, while order dated 2011-2018, while being pleased to issue notice, noticing the issue notice in the matter, upon consideration of the issues arising in the matter, was pleased to issue an interim direction to the effect that the impugned orders dated 9/11/2008, impugned order dated 9/11/2018, and the consequential step taken thereon, while the communication dated 12/11/2018 to remain stayed. Also, it is seen that thereafter, neither the society nor the respondent of the corporation department had moved before this court, praying for a vacation of the said order, neither and or no affidavit has been so filed in the matter by the respondents herein. Also, in view of the above position, without going into the issue as to whether the order dated 9/11/2018 was so passed in proper exercise of jurisdiction by the authority so issuing it, the present writ petition, the said orders in view of the lapse of time occasioning in the matter, and there being no allegation brought on record after the passing of the interim directions that the petitioner was continuing to commit misconduct in the matter, the orders dated 9/11/2018, as well as the communication dated 12/11/2018, stand set aside. Also, having interfered with the order dated 9/11/2018 and 12/11/2018, it is provided that the society is at liberty to proceed against
Board
the
of Directors.
Board of Directors
Under
of the
Section
said
38.
society, in exercise of the powers as vested on it under the provisions of the Assam Cooperative Societies Act 2007, to proceed against the petitioner for misconduct, for any misconduct that may have been committed by him, which also may be the reason for issuance of the said order dated 9/11/2018, in accordance by adopting a procedure known to law. Also, the petitioner shall be, in the event of institution of any such proceeding against the petitioner herein shall be allowed to, shall be given full liberty to place his defense in the matter. With the above observations and directions, the writ petition stands disposed of.
Lordship, the order passed by your lordship will be considered as the direction passed by this court to initiate a proceeding against me. So
We'll have to, because the nature of the allegations.
Lordship, the
nature of the allegations.
But allegations are not against specifically.
Be that as it may, you were running around from the vigilance also. Vigilance was behind. If there is no misconduct, no proceeding. If they have instituted any proceeding against you without misconduct, very serious allegations, Mr. Because of a technicality, I've interfered. Otherwise, I will not have.
Only one observation, Lordship, if they desire. Only if they desire.
Naturally, the board of the board of directors of the society, on consideration of the matter, if a misconduct is so evident against the petitioner for any act, any misconduct committed by him, including the allegations as contained, including the allegations leading to the passing of the order dated 9/11/2018, the board of directors would be at liberty to proceed against the petitioner in a manner known to law.
Yes. I'll ask your lordships to quote the section 38, subsection 2, my lord.
You advise.
My lord.
You are there.
Item 9.
Instruction, my lord.
Huh?
I obtained the instruction.
Ah.
But as it became precious.
That is it. I know that. 2018 order, do you think it will continue to operate till now? Mr. HZ Ahmed, Learned Counsel for the petition. Heard Mr. HZ Ahmed, Learned Counsel for the petition. Also heard Mr. DP Bora, Learned Standing Counsel, Health and Family Welfare Department, appearing for the respondent number 1, 2, 3, and 4.
I'm for respondent number 5.
Also heard Mr. S. Chakraborty, Learned Counsel, appearing for the respondent number 5. Also, the Learned Counsel for the petitioner on instructions have submitted that the issue as arising in the present proceedings has already lost its force. The order dated 5/11/2018 has already lost its force, and accordingly, he submits that there is no further issue arising in the present proceedings for consideration by this court, and also in view of the above prayer, which is not objected to, in view of the above submissions of the learned counsel for the petitioner, which is not objected to by the learned counsels appearing for the respondents, the represented petition stands dismissed as having become infructuous. 18 order.
Item 10.
Almost covered.
Yes, no.
How can
2009
this almost covered be? Where is that letter? Where is that equivalence letter? Page annexure 16.
Yes, no. Lordship, it is, I think, covered case of, Honorable Supreme Court has passed on, reported in 2019 to SCC 404. Lordship.
2019.
To SCC 404.
What is the ratio? Your specification was very narrow. IIT from a government recognized institution, right?
Yes, sir.
Oh, Zahur Ahmed. Many judgments have come. A recent judgment is there. My Lord Justice.
12 SCC also.
Ah.
This case was.
Ah.
Lied, Lordship.
Okay, nobody is there. If they have something, they'll come back. We will not go on merits. Otherwise, there is nothing here.
Nothing else. And they have
None
not,
appears for the petition on
Lordship,
call.
they have not challenged the rejection. General.
I know that. Forget it if they have not challenged also,
Yes.
but they have not, they have themselves admitted that the equivalence is nearly covered.
Yes.
Nearly covered cannot be accepted. But none appears for the petition on call. Maybe the last date, it was said that he will receive instructions whether it should be proceeded with. Maybe they
I
are not.
informed last occasion learned senior counsel PJ Soikia was appeared. So I informed his junior that they are engaged matter, Lordship. That's why.
Okay, forget it. If they want, they'll come and file an application. None appears for the learned counsel for the petitioner. Mr. K. Kolita, learned counsel. Learned counsel appears on behalf of the respondents.
1 to 4. Lordship.
1 to 4. Full stop. In view of the above, the present petition stands dismissed for non-prosecution.
Hello. 11.
It is not before Lordship is asking for family pension, my
We got it.
lord.
Now, Mr. Counsel, you are appealing for the first wife.
Respondent number 5.
That is the first wife.
Yes.
You have filed a very big affidavit. But tell me, have you challenged the order of ex parte divorce?
Well, also actually, and this counsel is going suffering from viral fever. So I pray for adjournment for today.
Friday. And what happened to the proceedings in that wherein she has questioned your marriage?
I am contesting.
It's not disposed of.
Not this photo.
So
But
see that
ex parte's husband was not silent.
huh?
Ex parte's husband, my lord.
Was not considered.
Not silent, my lord.
No, no, then what is there?
Finally,
Yes. Ex parte divorce degree, nobody is contesting.
Lordship.
So
They are only, my lord, my marriage certificate was silent.
challenge. No, because that will have a bearing.
My lord.
Because she says that you were never a wife. You were never a wife. So what we do is, they not having challenged the divorce degree, we'll hold that they are not entitled. They are not having the status of a wife. The children may be entitled if they are within the age limit.
My lord, in dependent, where is the dependent is written, my lord? They
Need not be, need not be.
They
Need
are
not.
already major, my lord.
Major.
Major.
Daughter married.
Married or not?
If not married, she is entitled.
I will take instruction, my lord.
She is entitled. 1. 2. Your entitlement would be subject to the civil case that is pending.
Where, my lord, the family court.
Family. Because that is under challenge.
But there is no stay order operating, my lord.
You go up on appeal.
On Friday, my lord.
Friday. Friday.
Right.
Yes, Mr. Bhuyan.
My lord, item number 3, my lord, basically it is become infectious because, my lord, after order, my lord, they have gone to the appeal, they have gone to SLP.
No, we will not. You want it to be dismissed as infructuous.
Infectious.
You have got your money.
No, my lord, not
Then-
yet. Not yet.
Then there has to be an order passed that you will be entitled under that first notification. So we'll pass that.
Trust. Only my presence to be
Ah,
recorded,
ah,
my
ah.
lord. I was like.
No, I have no problem. If you want me to dismiss it as infructuous, I'll do it in 2 minutes. Then, but what benefit will you get?
12.
No, I am a lead man to the rank of overseer. So I am entitled to have the scale of.
Mr. Dasgupta.
I'm entitled to have the scale of overseer, but they have adopted a policy to the effect that unless I have the diploma degree, I am not entitled to. That is their basic case. And admittedly, I don't have that degree, diploma. Now, Lord, whether so far the 6th Pay Commission report is concerned, that has not said so. And based on that commission report, one judgment has been delivered by this court. And the read appeal, and it went to the read appeal and read appellate court.
Ghanshyam.
And federal answer. Only difference is that in that case, I am a lead, in the present case, I am a lead man. And in that case, there are some, there is something else.
There are overseers, there are charge electric mechanician, charge electrician,
No,
charge
they are not
vehicle.
overseers. They are not overseers.
They were masons promoted as masons promoted as
That is.
Initially they were masons. And after qualifying themselves to a trade test, they will the next post. I don't have.
Overseer.
No, I don't have. What is the post? I don't know.
Overseer.
Overseer. And my rank is also painter. And I had completed my trade test. And I was succeeded. And I was a lead man. Scale of pay of these two was same. Rank is same. Now, for that case is concerned, we have to adopt a policy that unless you have a degree of diploma, you will not get it. And that led him to go to the court. And court has cleared his way. And they preferred a read appeal, and read appeal was dismissed. Now, whether that case is applicable on me or not, that is the question.
What is your answer to that?
My answer is that we are the similarly situated person. Rank is 7, scale of pay is 7. I have been qualified from painter to next post, lead man. They were qualified from mason to mat.
Mr. Dasgupta, I'm sorry, but that is exactly not the proposition that has been laid down by this court. This court said, in this court, in Ghanshyam's case, he was a non-diploma overseer. When he was promoted to that post, he was not given the pay of the diploma overseers. This court, on interpretation of the rules, said that no, when one more factor, the 6th CPC said, wherever the entry qualification of a particular post diploma is applied, that is 5,000, 8,000. That will be given to that post.
It's a date.
No. What has happened here is, here in the overseer's case, non-diploma overseer and diploma overseer were doing the same work. But the non-diploma overseers were not being given the scale of 5,000, 8,000. This court said, as the entry qualification of that post is a diploma, you, a non-diploma holder, will also be entitled because you are doing the same work.
I have been promoted from the college.
In your case, lead hand administrator now, earlier non-technical, and overseer are at the same parallel place. But the problem here is, lead hand technician, there is no direct entry by applying the eligibility of diploma.
I could have corrected, please.
In the overseer post, there is direct recruitment and promotion. For direct recruitment, minimum
Diploma holder.
qualification is
Diploma. holder.
diploma.
Hmm.
Now, that was held to be equivalent
Hmm.
to your non-diploma
Hmm.
plus a particular period of service.
Yes.
And that promotion is from masons,
Yes.
right?
And my promotion is from painter.
Painter. So in your lead hand, there is no direct recruitment. It's 100% promotional post. So the diploma is not applied to that post as an eligibility criteria. So your case cannot be covered by Ghanashyam.
All right, well, let's get matter will be after tomorrow or something.
Tomorrow.
Tomorrow I have some cases.
Day after. Heard Mr. A. Dasgupta, Learned Counsel for. Otherwise, I'm ready. I heard Mr. A. Dasgupta, Learned Counsel for the
I have an
petition.
arguable case.
Also heard Ms. B. Sharma. We'll give Mr. Das. Let him go through it. Also heard Ms. B. Sharma, Learned CGC appearing for the respondents. So heard the parties at length. List again on Friday for further hearing.
Just a well, your lordship's proposition is again.
Mr. If you go through that judgment of Ghanashyam, you will find that the post of overseer has both elements of direct recruitment and promotion. A promotee from Mason, he did not have that diploma. But a direct recruitee will have to have a diploma of 2 years or 3 years. So that post having a diploma qualification, in terms of 6 CPC, it was given 5,000, 8,000, right? These promotees who came in as non-diplomas were not given that skill. They were given 4,500, 7,000. They came up before this court. This court on examination found that the post having a diploma qualification and the diploma holder overseer and the non-diploma overseer doing the same work. This court directed that the non-diploma holders will also be paid 5,000, 6,000, 8,000. 8,000, 5,000, 8,000. Now, this went up on appeal and appeal dismissed off. Leading hand administration, whoever you are, you similarly situated persons went to Delhi High Court, sought application of Ghanashyam. Delhi High Court rejected that. It's on record. Similarly situated persons in charge, they were charge electricians, charge mechanics, like your peasant, painter, and all those things. When they were promoted as, no, they were vehicle mechanic and something like a vehicle something. Their promotion is charge electrician, charge mechanic. They were that charge electrician and charge mechanic. Again, there is a direct recruitment with diploma. They were not given. This court, Pramod Kumar, in that case said that no, applying the principle of Ghanashyam said they are also entitled because they were doing the same work.
Look,
Here it's not there.
I have picture of Delhi High Court.
Friday.
Item 13.
Here, Forest Department was directed to file on affidavit.
Forget it. You come to the meat of the matter.
But if the
Date of death,
petitioner
13/1/2010.
13/1/2010, she made an application on 25/3/2010.
So from 10, we are in 2014. What compassion is left?
Her case was never considered by the
Can't help it. Debabrata Tiwari both ways cuts you.
para 15. Debabrata Tiwari is there.
Withdraw.
Give me an answer for that.
I'll pass an order.
Because Debabrata Tiwari 15 is very
Okay. But Mr. S.N. Tamuli, Learned Counsel for the petitioner. Oh, we'll pass the order. We have the covered case, we'll pass the order. Disposed of.
Item 14.
Disposed of, no, dismissed.
May I please, Your Lordship?
We have that order, it's a similar order, so it might get.
Because of my lordship non-releasing of the arrears salary in the year 2017 to 19 only because of the typographical mistake of my name, my lordship.
Yes. You are appearing for whom?
I am
Woman.
the respondent, Brahmaputra Workman.
Yes, what is your stand?
My stand is that he did not join, as per that in transfer order, he did not join into the Zang, and there is no proof that he went there and he requested to join there, my lord. That is our stand, my lord. There
He
is
is retired now.
Yes, sir. My lord, can I take in the next week so that I can take whether the status of his arrear salary? Otherwise, there is, I think, only the part of arrear salary, I think.
Yes. That is from the
Period of
20, that is for the 21.
Period.
Period 27/8/17, my lordship.
27?
8/17. And from 10/4/2019. Total in 21 months.
From 19 onwards, you are getting your salaries.
If the typographical mistake already made it, and then I joined, and then 21 I already written.
What were you doing for these 2 years?
My lordship, as because my name is written as.
No. What were you doing for these 2 years?
My lordship.
You are not working.
Yes,
Working?
my lord, not working, my lord.
I am not allowed to join, my lordship. That is why number 2-3 repetition was made, my lordship. Accordingly, speaking order was there, my lordship.
They did not submit anything, that they went there and they requested the authority to join, my lord. In our affidavit in opposition also, we stated in some letter communication.
Communication is there, my lordship.
Page number 9, my lord.
Representation dated 5/7/2018, your lordship. Then 12/9/27, your lordship. Page 25, your lordship.
Earlier round of litigation was there. 1998. Where is that order of this court?
That is page
30.
45, my lord.
31,
No.
there, one,
Page number
then
31.
on that basis, my lordship, one speaking order plus, my lordship, that is at page 33, your lordship.
My lord, speaking order is page number 33.
34.
33. 33 is a type copy, my lord.
Okay, fine.
Here, my lord, page number 11 person 33. That is dated 6 September 2018. Represents class 4. Last portion, my lord, in 34, my lord, directed to join in that Zhang, my lord. And as per our letter, that is page number 9 of my affidavit in opposition, till 17/8/2018, my lord, he did not join. That is
Okay.
the communication, my lord.
So you joined on 21/9/2018. What happened then?
No, my lordship, kindly go through the page 38, your lordship.
No, that's, I'm holding it. You joined on 21/9/2018. What happened?
So I am not allowed, my lord. Then your lordship kindly came to page 40, your lordship.
Further order of this court.
After that, that 41, page 41, that order was passed, my lordship. Then only I was supposed to allow, my lordship.
You're a work charge employee. Work charge employee. You're a work charge employee. He's a regular employee or a work charge employee?
Khalasi regular, Khalasi.
Regular.
When did you retire?
35/21, my lordship. 31/5/21, my lordship.
You are getting your pension.
But that arrear salary is not released.
That you are not entitled. Yes, Ms. Gan.
My lord, my submission is that as per order of the speaking, after the speaking order also, he did not join in that in the junk, my lord.
No, he joined. He joined.
Page 38.
He joined on 38. So till that day, we will hold that he is not entitled to anything. 21-9. But you did not allow him to join. And accordingly, he again approached this court in 2019. This court by order dated 1/4/2019.
Then only I am allowed.
Then he was directed to report. He reported and you allowed him from 23/5/2019. So why you are limiting your prayer till 10/4/19? Why are you limiting your prayer non-payment till 10/4/19?
Because after joining, I am getting.
You joined on 10/4.
Yes, sir.
Where? Because page 44 is 23/5. Hmm. So you are working from 11/4.
Yes.
How do I know that? Okay. They paid you from the date of the order of this court. You had taken advantage because you were released from the office here 17/8/2018,
Yes.
right?
Yes.
And the next letter, the earliest letter we find is of
5/7/2018.
where is 5/7/2018 representation?
Yes,
Okay.
my lord. 5/7/18, annexes 6, my lord, sir, that page. 27.
Now come to this thing. So after around 1 year, you submitted an application. You were released on 15/9. You were released on 27/8/2017. You submitted an application for the first time on 4/7/2018, right?
Yes, sir.
Now, therein, that was followed by 5/7.
Yes. No, my lord, sir, first approach before on 12/9/17, my lord, sir, as my wife is.
That is to the vice chairman for cancellation of the order. So that is not for joining.
Yes.
So after the orders, you had submitted an application on 5/7.
5/7/18.
5/7. Therein also for correction of your name.
Yes.
Then you came up before this court.
Yes.
This court on 3/8. Right?
3/8, yes.
Disposed of the representation. Then the speaking order.
6/9, my lord.
So their specific contention 12/9 to 4/7/2018, you did not make anything. So accordingly, you were directed to join without delay, so and so, so and so, so and so.
That is on 21/9/18, Your Lordship.
Then what had happened was you submitted a joining report on 21/9/2018.
Again, I am not allowed.
Then you come up before this court.
Yes, sir.
On 1/4, this court disposes of the same, saying that the earlier order of transfer now has been recalled, so you are going back to your place. So, madam,
Yes, my lord.
why not from 4/7/2018,
7/2018, my lord.
when she approached you?
Yes, sir. That is as per
Page 33's third paragraph,
38.
33.
33 speaking order. my lord.
That third paragraph.
33 speaking order dated 6/9.
9. Therein you refer to a letter dated 4/7. Right? And you say from 12/9/2017 till 4/7, she did not respond to you.
Yes, my lord. Received. Yes, my lord.
So you knew that she was there from 4/7 with you. She was ready to join. Now, in the penultimate paragraph at page 34, you say that in terms of that 5/7, you joined. And accordingly, he joined on 21/9.
My lord, as per this page number 33, my lord, uh, my understanding is that from the day of his release, that's 12/9/2017 till 4/7/2018, he has not made any communication.
Be that as it may,
Yes,
on
ma'am.
4/7, at least he made a
4/7,
communication.
yes, my lord.
And by this time, this order of transfer was reversed by you.
Yes, ma'am.
All those people were brought back.
Yes, my lord.
So there is no point in him going and joining before the transferred post. So he approached this court, and this court in page 43 directed him to report to Brahmaputra board.
Yes, my lord.
And that order came on 23/5/2019, but you made it effective from 10/4/2019. So if you are making it effective from 10/4/19, it should be effective from 5/7/2018.
4/7,
5/7,
5/7, yes,
5/7.
5/7. Yes, my lord. That is.
So for that period,
Yes, my lord.
release the areas.
My lord, maybe take on next year. I'll take instruction whether they are, what is the status of the release of.
Tomorrow.
Tomorrow. Yes, my lord.
Kali.
Oblige, Your Lordship.
Item 15.
This is my lordship, compassionate appointment, my lordship. Compassionate appointment, my lordship.
Appointed.
Yes, sir. Not appointment, my lordship.
When is the date of death?
8/11/2010.
When did you apply?
Applied on
13 minutes.
13, Your Lordship.
After 3 years.
Yes.
And your case was never considered. Huh? Mr. Chakraborty, her case was not considered.
No, my lord,
Because maybe there is no
considered-
vacancy.
Considered earlier along with others, but her name was kept, my lord, in the list, my lord. in
Have
the
you approached
roster.
this court before these proceedings? No.
But roster was published, my lordship, but till now I am not considered.
Okay, fine.
There is no vacancy, my lord, we have said. my lord. The similar orders are being passed, my lord, not just one. I have a next one. There are others, my lord, as and when vacancy arises, the cases will be considered.
No, today we can't pass that order. We'll have to dismiss the writ petition.
My lord.
Because the
Oh.
death is of 2010.
Not.
No compassion. Devobroto Tiwari. Sorry. Dismissed.
Oblige, Your Lordship.
We are dismissing.
Not.
Or similar matter. Mr. Vaishya, you're not here. Item number 17. You're not. Yes, madam.
Your Lordship, it was directed to the respondent authority to take instruction.
For what?
Because as per their contention, the all papers were ready except the death certificate that has to be submitted by the petitioner. And it was
What is the relief?
Your Lordship, the petitioner approached before this honorable court seeking family pension, being an unmarried and specially able daughter of the
Yes.
of her late
Yes.
father.
Who is appearing?
It was
GAD.
Standing counsel is there.
Huh? Get the standing counsel.
Yes. Dada.
Mr. A. Fukon. Oh, you are there? Yes. Why not paid? Pension, why are not processing?
On last date, Lordship, my colleague appeared, Lordship. I'm informing him, he will.
Just get it. Madam, be here. Where is the document to show that you are not married and you are disabled? Any affidavit file? Yes.
Lordship, disability certificate is annexed 6, Your Lordship. Page 25.
Now, why are they asking for your death certificate of your mother? Your mother died.
Then the father, Your Lordship.
Mother died earlier. Then your father died. Who was the employee?
Father, Your Lordship.
Father was the employee. And after the death of your father, they have not paid you even a single.
Though I have applied, but they have returned it back stating that few documents are left and required to be furnished, and that is the death certificate. In the affidavit in reply also, Your Lordship, submitted by the respondent number 3 in para 8 of page 5 of their affidavit in opposition, Your Lordship. They have all clearly stated, as soon as the petitioner furnished the death certificate of
Why are you not furnishing the death certificate?
already furnished, Your Lordship.
When? In your reply, you have stated so.
No, Your Lordship, it was subsequent to that, Your Lordship.
Can you give me the date?
Yes, Your Lordship. When she has filed.
Unnecessarily handled. Get the standing counsel. Yes, Mr. Fukon. What is this? What is this?
I'm paying for the respondent number 1, Your Lordship.
You are the one who will have to make the payment.
My lord,
GAD.
GAD, my lord. My lord, sometime maybe given.
No, 2 o'clock. Get the instruction. Why it's not being clear? She has said that family pension, a disabled lady, she is waiting. Will not permit. 2 o'clock. Get your instruction. Give him the particulars, madam. Give him the particulars. And she has also said, Mr. Fukon, the only ground taken here that the mother's death certificate was not there. Mother had died much prior to the death of the government servant. So she says that the death certificate has also been submitted. So now, get your instructions. 2 o'clock, we'll finish it.
Yes, Chief, matter is regarding master role worker, Lordships. At present, petitioners are not working. Petitioners are not engaged, Lordship.
When were you initially engaged?
They were working from 1/4/1993.
Lordship, here perhaps finance is a necessary party in the case, Lordship.
Any affidavit filed?
No, Lordship.
Yes. What is your right?
See, one more thing I want to add here. Earlier, this Honorable High Court on 5/3/2024,
In this case,
dispose of similar matters.
where is that order?
Order is WPC 3009 of 2017.
Where is that?
3000.
Where is that order? It's on record. You have a copy.
Soft copy on
Give it to her. She'll take off.
WPC 3900.
WPC
3900/2017.
order dated
5/3/2024. Dispose of 177.
What was the directions passed?
Direction given that to re-engage or reappointment appointed to the petitioners, and there are more than 3000 petitioners.
In that case,
Yes, Lordship.
To re-examine their appointments, Lordship. In that case, order was that to re-examine the appointments, Lordship.
give me a copy. We'll have it after 2 items. We'll have it after 2-3 items. Later, apni ulai lo. Eto duta man item pisot mat dibo.
Non-payment of gratuity and the benefit.
Yes. What is the instruction?
Lordship, I need my lord, this matter may kindly fix up day after tomorrow, my lord. Yesterday, my lord, APCDC has sent communication to the Government of Assam, my lord, Soil Conservation Department. And my lord, they will give in written instruction to me, my lord. So day after tomorrow, kindly may fix, my lord. And my lord, 37 numbers of my lord employee, those who are retired, my lord, and expired, their FOC has been prepared. But 25 numbers of employee, my lord, this where my lord, these petitioners were names also included, my lord. This my lord, this list was not sanctioned by the Finance Department, my lord.
Why?
My lord, that the best answer will be given by the Finance Department, my lord.
Now, what is the letter written to the government by you? What is the communication?
I have sent, my lord. Yes. This one.
Were there any orders of termination in your case?
Discharge.
Discharge.
Please step.
Have you challenged this?
No.
Then?
But I have completed my minimum qualifying service as
No,
per-
if this we hold it to be. And what is this order? No proceeding, nothing, then?
Yes, my lord. Only paper publication was there, my lord.
Paper publication is not.
Yes.
This is your communication.
Yes, my lord.
I wanted the
Department, my lord. Department, my lord, yet to receive, my lord. So kindly fix day after tomorrow, my lord.
this order will not come in the way. Page 10.
Only telephonic, my lord, communication that.
And we had asked you way back on 25/6.
Yes.
This letter has gone only on 23/7.
I apologize, my lord.
This is the only thing. Government has given a sanction, but that has not come to you. Day after tomorrow. Apni file to thodi boy. By slip pathai dibo. Etu ghurai dibo. I want the instructions, so we'll ask your secretary to be here at 2 p.m.
My lord, if these matters don't come before your lordship, it could be difficult. Lordship may kindly
No, it's
report
coming on Friday.
Friday, but if the order.
If it comes before anybody else also, the thing is there. But this will come before this High Court. That much I can assure you.
Oblige, my lord.
Well, these two matters are reservation and promotion matters. It may please your lordship. My lord, this matter pertains to reservation.
Any bar in me taking up this matters, Mr. Randhu?
No. Reservation in promotion matters.
Long time I have heard this matter.
My lord. What happened, my lord? The petitioner in the first writ petition, that is 4319.
How many writ petitions? 2 writ petitions.
2 writ.
4-3?
My lord.
Four three 19
My lord, 431.
of 2021. Yes.
Page 31 is the merit list of the petitioner who joined as superintendent of taxes. Here, my lord, the petitioner number.
This is your initial entry.
This is the merit list. This is 31 is the type copy. 31A is the.
Here you are at serial number 1, 6 and 1 and 6, 2 writ petitioners.
My lord.
Anil
And
Kumar Jalan
private respondent
is at serial number 12.
12.
Okay.
And thereafter, by annexure 2 at page 32.
We are taking it up for final consideration.
In fact, only one thing, the stand of the government is really required for the simple reason.
If there is something, tell me. If I move into it, then you come back, it'd be difficult.
No, Malad, the government stand.
Nobody is there.
The problem is
So
that.
you both break your heads, I will see whose head more blood comes.
No, my lord, what has happened? The stay order is for 2 years. My stay, because of the stay order, I cannot get my promotion. I was promoted already to the joint commissioner rank. This stay order from 2021, this has been, he's been enjoying the stay. So naturally, lordship will go for a early disposal, final disposal. Only I just wanted to know the government stand. Government has not given any.
Now tell me what had happened. Let me see. The government stand is at least required.
Before starting the matter, Manoj, I would like to point out, Manoj, the finance department has filed a affidavit in opposition. There, Manoj, their private respondent was in the other case, private respondent case was considered by the DPC, in spite of the stay order, and that was held, withheld, till finalization of this case. Meanwhile, in their affidavit, the finance department has stated that they have already made another gradation list wherein the present lead petitioner is above the private respondent.
So what is there left now?
My lord.
Finished. You have done it.
He
Let
has
them,
not challenged it.
no, let them go and implement that. That was your grievance.
My lord, only thing is, if that DPC order is pending,
That we will interfere.
my lord,
Now tell me, you joined as superintendent of taxes.
my lord.
Then when were you promoted?
My lord, the private respondent was promoted to the assistant commissioner on 15 November 2010. And I was promoted on
You were promoted,
I was promoted on 28th July
both of you,
2013.
20th July,
2013.
both of you,
To the post of assistant commissioner.
both of you,
Both of us.
ACT.
My lord.
Then
Then what happened, my lord?
DCT,
In the year,
next promotion,
next promotion was given, my lord, to the post of deputy commissioner.
private respondent,
Deputation commissioner, both of all the petitioner and the private respondent were promoted together, my lord. In the year 2018, my lord.
31/10/2019.
My lord. My lord.
Okay.
My
Then?
lord, meanwhile, there is a judgment of your lordship, which is at page 76. At page annexure 18.
Rajesh Kumar Agarwal.
Yes, my lord. In this case.
Not mine. It's not my judgment. I appeared.
This court judgment, my lord. Hey, here, my lord, it was categorically held that in the cadre state of joint commissioner, that is 5 cadre state, there cannot be any.
So
reservation.
DCT, next is JCT.
After they are now for the promotion to the post of JCT.
Okay. Joint Commissioner
Yes, my lord, joint commissioner of taxes.
is the issue in question now.
My lord.
So
Here-
cadre strength of JCT is 5 posts.
5. Here, my lord, kindly peruse.
Now,
Yes.
which is the year when you were all eligible for being considered?
My lord, 2021.
2021. Right, Mr. Das, 2021?
My lord?
The year when you all were eligible for being considered
Yes.
is 2021?
Only the, in the speaking order of the government on 18 January 2021, he was not eligible because he had not passed the departmental examination. That was a
Forget
specific
it.
standard
That
of
are nitty-gritties. Now, in 21, you all were eligible. And that is the time when the dispute started.
Yes.
Right? So,
Madam.
year 21, 5
My lord,
posts.
kindly peruse NHS 16, page 70. That is the gradation list, my lord. Page 70.
Okay, 5 posts of JCT.
My lord.
As on 2021, what was the man in position? Man in position, 5 posts. How many vacancies were there?
There were 3 vacancies.
3.
3 vacancies.
And the other 2 posts were filled up by?
Filled up in the other case, it was there, my lord.
Just give me that data.
My lord.
Those series matters, Mr. Das, has been.
That has been disposed.
What is the
Went
fine?
before the division bench,
Ah.
Bhagavan Pata's judgment, the division bench said that it will be cadre-wise in terms of the Supreme Court judgment. Then, in fact, the government came up with another notification. We challenged it. That was rejected before the single judge. Now we have filed an appeal that is admitted.
So that is also rejected.
That OM doesn't come here because it is prospective. That is to January 2020.
Now that issue, whether a person getting a promotion on accelerated basis, his seniority in the promotional post on his seniors, erstwhile seniors coming in, will again be recast. That is the law holding the field.
No, Journal Singh is holding the field. That cannot be done. Because once this accelerated promotion is given, the
Okay.
consequential.
You want to go
seniority
back
is
to
increasing.
Janil Singh. Then we will bring in the concept of the, what do you call that?
Catch up.
Creamy layer and
No,
catch up.
creamy layer cannot be brought.
How
for
can
the
you
SC.
do away with catch up?
No, catch up is no more. Malad, catch up, the Assam government can bring 100 numbers.
You
of
challenge
OM,
that
whether it is
notification.
permissible
As
or
far
not.
as this is concerned, I'll only follow the notification. When the notification is under challenge and the
what
notification is set aside, then that will hold the field. What is the
How can it
latest?
hold the field when
What
I
is the
don't-
what is the latest notification you have
Latest,
challenged?
Notification is of January 18, 2023. That doesn't cover his case because it will be from January 18 prospective. His
Sir,
case is vacancies of 21.
You have a
and
copy
22.
of that?
Malad, we don't have, yes.
Malad,
Malad, the judgment is there.
other repetition, 109 page, Malad, annexure 18.
In fact, there's a judgment, I put
Malad,
Page,
there's
Mr.
a
Das,
Page
Mr.
109 of the read petition, Malad.
109. Ah,
2023.
Malad,
this will be retrospective, Mr. Das.
Malad,
This will be retrospective. This is clarificatory.
Malad,
This is clarificatory in nature.
this 2018.
18,
Malad,
23,
it is
23,
not
23.
because there's a order of the single judge saying it is prospective. Honorable Justice Barua's judgment is there. It is
Interpreting
retrospective.
18-123.
Yes, it
Huh?
will be prospective. In Sadikur Rahman's case, tax matter. Well, in fact, if I'm not wrong, your lordship had appeared in that Sadikur Rahman's case. There's a judgment.
Interpreting 18-123.
Yes, yes.
You have that judgment.
Well, right now, we'll furnish it.
no, Malad. Here, Malad, the.
And this is the one you made a
Well, I'm
challenge.
placing the law. I'm not going for adversarial
Mr. Das,
litigation.
we know.
Yes, sir.
18-123, you had presented a challenge to this.
I had presented a challenge.
But that was
The-
rejected.
That was rejected on one ground, saying that the 2023 OM of giving consequential seniority, the 2002 OM is not flowing from 78 Act. That was the finding of the learned single judge. And
rightly so.
basically the learned single judge went against two division single benches order of the Guwahati High Court. He never referred it to the full bench. This
You
is
have
the
that
plea we are
order.
taking up.
You have the order wherein you have presented a challenge to 18-1.
Malad,
You have the order of this
the
court.
judgment.
Huh?
Judgment.
18-123.
Malad,
The challenge.
Malad, I will place it.
4/6/2024 is the date of the order. That is
Well, 4/6/2024 is the order. Just
WPC?
WPC 363 of 2023.
36323. Copy of WPC. Okay.
Because our appeal has been now admitted by the division.
Okay, fine.
Malad.
Yes.
Malad.
Huh.
Your lordship asks about this when dated 18.
Forget all those. Now 21 5 posts were there. Right?
Malad.
3 vacancies.
3 vacancies.
2 were filled up.
By the DPC, 2 were filled up. 1 post was kept under seal cover for him.
He's under
Malad.
Department proceedings.
No, I'm not under seal cover.
What
is he
They
saying?
call it seal cover.
Well, if my petitioner today has brought my officer under suspension, I don't know. He will know better. He cannot use the word seal cover. There's no DP against me.
Mr. Das, that is only to make this court understand that 1 post is blocked. Nothing
Yes,
else.
and because of the stay order.
Okay.
Malad.
Now tell me.
Malad.
No, Mr. Busher. 5 posts, 3 are vacant. 2 were filled up. Who is holding those 2 posts?
Malad. They are not.
Category.
Malad.
General, reserve, what?
One of general, the other one is Malad. Reserve. But considered as general.
Okay, fine.
Due to seniority, Malad.
Reserved. Okay. Now, out of this 3 posts, how was it filled up? These are fresh vacancies.
Malad.
How was it filled up? It was filled. Recommendation was for whom? DPC. Where is the DPC, Manoj?
My lord, the DPC, your lordship will find in the affidavit filed by the finance
Finance
department.
Department, yes.
In the next case, that is 3565.
Okay, where is it?
At page 327, mother, annex 70. Malad, by these minutes, Malad, they ignored all the provision, Malad,
Just a moment.
including the WEM.
Just a moment. So if you come to page 328, right?
Malad.
328. The placement of the officers at serial number 6, you have been placed above the private respondent.
Malad.
Maybe by application of that 18-123 notification. Now let us see how they have done it. 19.
They
17,
considered the case of
17.
Rakesh Agarwal, Malad. In spite of that, they considered the recommended private respondent.
So this is the case. Yes, Mr. Das. Forget everything. Come to page 328 of the second case. 328.
328-29. Affidavit in opposition contains. Malad, 328 of whose affidavit?
The page 328 is the running page of 3565-2023.
Malad, what's the letter dated?
It's a minutes of the departmental selection.
Malad, we have the minutes of the meeting of 27/9/19.
No, 4/2/23.
We don't have.
Annexure
copy.
18 of the finance department's affidavit. You have not got it.
We didn't get a copy.
That is enough. It is there. How could have been granted the seniority? You could not have.
Malad, when we got our seniority, we didn't get it by.
No, the
We get by
committee,
merit.
the committee considered you as a junior to the
Where, Lord?
petitioners. That minutes you don't have it, you'll have to get it. So, Mr. Bosho,
Malad.
page 328 is violated in page 330. That's all. Why this? Give him a copy. Mr. Das, you have a copy of that affidavit.
Finance department, they have copied.
There is no requirement to go beyond this.
No, he has the copy.
You have a copy?
No, I have been given.
I know you go, we'll not trouble you. You go through it because that would be the basis. We'll have it on Tuesday for final disposal.
Wednesday. Tuesday, I will
Thursday.
be out of state.
Thursday.
Yes.
Finish on that day, we will go for final disposal. We'll only consider, because that is under challenge, we'll only consider the minutes. In the light of Rajesh Kumar Agarwal,
Basically, he was.
and
brought
now
up
you
to-
will have to show me how 2 reserve community candidates could be brought in.
But I went by merit.
No,
That is his
no,
case.
it's not by merit.
That is the contention of the DPCR. The
How
entire
can
case
it
is that
be?
he
If
got
it is
by merit.
cutoff marks is 15, anybody getting above 15, the placement will
But
be on the
only
basis of
problem is that
seniority.
They have applied the 2023 OM and my client has not challenged it. That could be the ground only.
Forget it. Heard Mr. G. Vaishya, Learned Counsel for the petitioner, also heard Mr. Petitioners, also heard Mr. D. K. Das, Learned Counsel appearing for the private respondent, as well as Mr. Ardhar and Mr. B. Gogoi, learned counsel, representing the state respondents. Parties have been heard at length. List again on 8/8/2024 for further hearing. Only on that aspect, Mr. Das, we will not go beyond that.
Well, I have been brought down pursuant to the 2023.
That is something which you will have to challenge independently.
No, definitely. What I find, if I don't challenge it, I don't.
You don't have it.
Question it. Therefore, let me inform my client.
So we have given you a brief also.
Yes.
Provided 8 days time, my lord.
8 days time, we have given you a brief
The
also.
final call will be of respondent 7.
No, nobody. If that be the position, we are going to interfere with the minutes, ask them to redo it in accordance with the provisions holding the bill. And you give me a small note, Mr. Bishop, how the matter went. Long time, Mr. Soikia, did not see you.
My lord, we have filed the affidavit today morning only, my lord. For respondent 2 and 4.
What is your stand, Mr.
They are not entitled, my lord. They have joined after, my lord, the cutoff date, my lord.
When was the selection process concluded?
My lord, selection process, select list was published in, my lord, in the year 2001 though. They were appointed, my lord, in 2007.
From that very select list? From that very select list, they were appointed? Because there were cases pending before this court? That is why?
By the direction.
Okay. They'll have to be. They'll have to be considered. There are decisions. You have the decisions of the Supreme Court.
My lord.
Yes, Mr. Naik.
My lord, that the honorable, our High Court.
Your case is simple. 2001, you were selected, but you were not appointed.
Not appointed.
You approached this court. Proceedings pending. Direction. Appointed.
Appointed.
But by that time, the new pension scheme, whether you will be covered under the old pension scheme or new pension scheme.
Because we are
Matter is covered.
The High Court held that the duty left on the part of the government.
You give me some decisions.
I place the decision, but my only submission is that date 1/2/2005 is statutory date.
It has become statutory in nature, but we'll have to apply it. Mister, there are decisions of the Supreme Court. I'm not carrying it.
No,
to
I have seen those.
you will have to apply it in the facts of the case.
Yeah, but-
If everything was concluded before that,
But there is a way, Lord. You are either on this side or that side, without challenging your.
and
date of
see, their
appointment.
appointments were not dehouse the select list. It was referring to the select
They
list.
have not challenged their date of appointment.
Okay, 1 minute. 1 minute.
In this petition, Lordship, they are only for.
So, the challenge here was to order passed by you on 18/6/2003.
If so far as prayer is concerned, they are only praying for. a
Forget it,
direction
forget it,
of
forget it, forget it.
submitting The GPF.
So 18/6/2003, you had refused their appointments. That was interfered with by this court. So as of 18/6/2003, this will have a retrospective effect. Interference goes from that day. Their rights revive on that day.
But
Anyway,
that judgment will.
you get me the judgments.
Lord.
Mr. Soike, they have filed an affidavit. You have got a copy. Today, they'll serve you.
They will.
Heard Mr. Assis Soike, learned counsel for the petitioner. Also heard
I'm just
Mr.
applying, my lord.
Ard learned counsel appearing for the respondents number 1, 2, 4, 5 also you'll appear. Pension is
No, pension, my friend is appearing. my lord.
4. Full stop. Also heard Mr. P. Naik, learned counsel, standing counsel, finance department for respondent number 3, and Miss A. Talukdar, learned counsel appearing for the director of pension. So Mr. Dhar submits that an affidavit on behalf of the respondent number 2, 4, 2 and 4 has been filed today. However, the copy of the same is not available on records. Also, registry to trace and tag the records of the said, track the said affidavit so filed today, along with the records of the case, and list the matter again on 19/8/2024. Mr. Sweke, on 19/8 we have put it.
My lord, the government has already decided to pay the old pension, which I have brought. That's it.
Mr. Naik, place those judgments in your favor.
Our High Court has judgment.
But you know the Supreme Court judgments which says, in such situation, Supreme Court has allowed. There is a division bench judgment of our High Court also. My Lord Justice Sridhar also, if I'm not wrong.
Lordship, we'll have to deal with the date, Lordship.
I'll do that.
Challenging the date.
I'll-
He is not claiming seniority.
I want to deal with it.
No,
That
he
is
is
why
not-
I'm asking you to give me your judgments.
That is what. He is not claiming seniority.
He will not get anything other than only the coverage. He'll not get, beyond that, he will not get anything. Not even pay, but the coverage, whether that would be extendable to him or not. Satisfy me.
Lordship.
I am not going to grant him seniority because this was not granted in the earlier round of litigation.
No, Lordship will not allow what I am submitting. He is not even claiming.
Forget it.
He has not challenged the date.
We
of
are
joining,
concerned with
date
the
of
issue.
adjournment.
People are before us. We are concerned with the issue. The only question is, given that the process of selection had come down, concluded in 2001, because of a decision taken by you in 2003, he was denied appointment, which on challenge but before this court was interfered with. Now, what would be the effect? Whether he will be covered under NPS or under OPS. That much only. Give me a judgment on that. On 9/8. No, 19/8.
Item number 41 may be taken up, my lord. We have filed the affidavit today, item 41. Let it come after on Monday or Tuesday, my lord.
On the
41.
prayer of Mr. R.C. Soikia, Learned Counsel appearing for the petitioner, registry to list those matters again after week on a date to be fixed by.
Obliged.
May I please, Your Lord? Your Lordship may not take this matter. Yes, a veterinary field assistant.
Oh, those cases.
Yeah.
List before any other bench without me. Registry to list this matter again without before a bench without me. So and so. Maybe I appeared in one or two matters. Yes.
Yes, sir. Date, can you say?
Obliged.
May it please your lordship.
Yes.
Lordship, in this matter, the rate petition number 5302, there is a pending salary which has to be paid to me. So before I go to that, I have produced one order of this Honorable High Court on the last occasion.
Yes, it's here.
The order is that is WPC 1558 of 2021, whereby the similar matter, the district is different. So 18/12/23, the order dated, it was disposed of. Similar matter, my matter is from district Moregaon, and this was, if I'm not wrong, it was from Kachhar, I think.
Yes.
Lordship, the matter may be adjourned for the day, Lordship.
No.
Lordship, I am appearing on behalf of A. Jahid, Lordship. He is
Fine.
out of station, Lordship.
A. Jahid is appearing for whom? The respondents.
Yes, Lordship. Respondent number 3, 4, and 5.
Outfit. The employer.
There are two judgments holding the field. Why should we not follow those? Your total dues is around 7 lakhs
Yes, Lordship.
58,000.
Yes, Lordship. And the similar matter where it was disposed of, the amount is much higher, and it was in that order, it was,
Where is Mr. Jahid gone? He's coming back today.
Lordship, he is in Goalpara, Lordship.
Golpara.
Yes.
Call him. Ask him. Take instructions whether this similar order can be passed. Because you have filed an affidavit here. Have you disputed that position? Let us see.
Lordship, only for the day, Lordship.
Huh?
Only for the day, Lordship.
Tomorrow. Why keep this matter pending? They are hanging. Tomorrow. Kali slip on DD apni. As prayed for by on behalf of Mr. A. Jahid, learned counsel appearing for the respond number 3. Respond number
Respondent number 3, 4, and 5.
3, 4, and 5. List this matter again tomorrow.
I am appearing for 1 and 2, madam.
Mr. Adhar appears for respond number 1 and 2. There is a proposal directed to be a very reasonable order. We'll pass that only if you dispute his contention that he is entitled to any area, he is not entitled to any area. So tell me that. Finish. But your affidavit does not say so. His affidavit is again financial hardship. That is covered. Or you just ask Mr. Jahid, we'll dispose it. Okay, tomorrow.
Deeply obliged, Lordship.
No reply is being filed?
No, Lordship, they have filed, Lordship, Commissioner said, kindly, Lordship, come to the order dated 7/12/2023. That is the case, Lordship. 7/12/2023.
7/12.
My lord, this matter may be taken up after some time, my lord. Mr. D. Nath, senior government advocate, is appearing.
No problem. You wait. We'll not proceed. We'll hear him. Mr. Vaishnav, you are also similarly placed.
Fine.
You are also wanting direct recruitment.
Actually, I'm working as temporary as working work charge.
Work charge.
Work card, Anganwadi work card. My service has not been regularized and.
There is no provision for regularization. It's either promotion or by direct recruitment.
I have given my land to the house. And in my land, they have taken my land, the department, they constructed the center.
So your case is that it should not be only by promotion, it should be by direct recruitment.
Should be to the promotion and rest 75% should be direct.
75%, that 75, 21, 25 differentiation, will it be on the basis of the state or ICDS project? 25, 75, that division,
Yes.
it should be made in the state level or in ICDS project level?
State level, Lordship.
State level.
Yes.
Yes, Mr. Sikdar, what is your, why don't you come this side? You're supporting. Yes, Mr. Nath.
When the posting center is created new.
Then they said that policy will not come in. Then the stand of Mr. Nath is that the direct recruitment will be made, promotion will not be there.
Yes.
But yes, Mr. Nath, what is this?
But the stand of
These are schemes given by the central government. You are just an implementing agency.
Yes.
Now, the petitioner state that there is a central government guideline.
Yes.
And I also remember in that book, there is a book.
Yes.
You have seen that book.
Yes.
So, that wherein everything about this ICDS projects are given.
Correct.
And therein also 75-25.
25%.
There is a decision, I suppose, of Calcutta, from Calcutta it went.
Calcutta, yes.
75-25. And I think there was a matter wherein I also had appeared, wherein the promotion from Anganwadi to supervisor was Anganwadi worker to supervisor. And therein also with the same guidelines which you followed, which you wanted to implement, therein somewhere it is said that 75-25 would be Anganwadi helper. Now, what is your stand?
From the secretary, we have filed an affidavit in the matter. We have said that the 25% as per the guideline of the central government we are following. In the ICDS project where this case is from, there are 400 total Anganwadi centers, and out of
Mr. Counsel, please.
Out of 400 Anganwadi centers, if we calculate 25%, it comes to 100. Now the stand of the department is that now as on today, 21 numbers of Anganwadi helpers have been within that ICDS project have been upgraded. So still 79 we can go for, and therefore the advertisement was issued for upgradation of those Anganwadi workers.
You mean to say that this will be 75-25 would be applied?
Yes.
For the Anganwadi centers under a particular ICDS project. It's not for the state as a whole.
No.
One. So your case is by applying that 75-25, you have upgraded. There will be total number of upgradation required. How much?
Total Anganwadi center is 400 within that ICDS project.
400.
400.
Okay.
So 25%.
So 100 you can upgrade. You have only upgraded 21.
Till date, 29 is there.
29. Okay.
Sorry, 21.
21. So 100 minus 21 would be 89.
79.
79
we can go.
You can still do for 79.
Yes, 79.
And all these repetitions is from the same ICDS project.
ICDS project, from Dhubri, Gauripur ICDS project.
Dhubri, Gauripur.
Gauripur ICDS project. What they have challenged here, they have challenged 2 advertisements which were issued for upgradation of the Anganwadi helpers. They said that the entire vacancy has been advertised for upgradation. They are fresh candidates. They said that some scope may be given them to take part in this election.
100 gone. The other 300, what is the position? All direct recruitments.
Those are already, those are either some Anganwadi workers are working, or if it feel that instruction I don't have, because the Anganwadi workers, those Anganwadi.
So if you are trying to make this differentiation, you must also show that the direct recruitment quota, if not fully filled up, but is filled up.
The centers, kindly, 2 things are very important for this case. Number one is the upgradation. The Anganwadi helpers and workers, they are selected from the survey area. Suppose if the petitioner belongs to this particular Anganwadi center, she cannot apply for other Anganwadi center. So even if within 400 some places are vacant, she cannot have a claim in that. Number one. Number two is the particular 2013 scheme. Following the guideline of the central government, the government of Assam has issued a notification of 4th of March 2013. That notification is on record. This provides certain qualifications and criteria. If the Anganwadi helper fulfills those criteria, then she will be given an opportunity for upgradation. But in that case, the Anganwadi helper within the revenue circle,
Well, within a revenue cycle, there may be 2 or 3 Anganwadi centers. So the Anganwadi center, suppose there are 4 Anganwadi centers, A, B, C, D. But if an Anganwadi worker dies or she gets promotion to supervisor or in somehow
The post is vacant.
Then the Anganwadi helper of all the 4 centers, A, B, C, D, they will get the opportunity to take part in the selection process by virtue of this notification.
But will it not be, you still will have to maintain that 75-25?
75%. That's true. That's true. Because whenever the vacancy arose at Anganwadi worker post, but then they will see the requisition will come to the director. Then they will see whether this 25% can be they can apply that or not. But here is a case the 21 number of Anganwadi workers are there. They already have been upgraded from Anganwadi helper out of 400 total. So 79 still they can. Now here the 2 advertisements were issued for those Anganwadi centers where Anganwadi workers post fall vacant either for death or for resignation or for promotion for some regions. So in those respect of the post, as per the notification of 4th March 2013, the persons who fulfills the qualification criteria given in that, and
They will be admitted.
they will appear.
Is 4/3/2013 under challenge in this?
No, this is not a challenge. The simple case of the petitioner is, if Lordship Kelly comes to the writ petition, kindly take WPC number 7502 of 22.
I'm holding that.
Lordship. They said in paragraph 3.
How many petitions are here?
Here
Only one, Asma Khatun.
One.
Okay.
The allegation is that in paragraph 3, the petitioner needs to say that on 8/7/2022, the CDPO ICDS CDPO Gauripur ICDS project Dharmasala issued an impugn advertisement whereby invited application from the helper who have completed 10 years for filling up the vacancies of 12 posts out of 20 posts by way of promotion. Another advertisement issued on 18/7/22 for filling up the vacancies of another 5 posts by way of promotion. They have, this is their allegation. Then the next thing is that the central government, the government of India, Ministry of Women and Child Development issued notification number 6/10/2006, wherein a decision has been taken to reserve 25% post of Anganwadi workers to be filled up from amongst the Anganwadi helper who have put in minimum 10 years of satisfactory service and also possess the requisite qualification. Then they said, about the notification of 4th of March 2013, there's an impugn advertisement dated 8/7/22 and 18/7/22 is issued without following the notification dated 6/10/2006 issued by the Government of India. Clearly mentioned that 25% of Anganwadi workers are to be filled up by way of promotion from Anganwadi helpers. They want to say, they basically want to possess that whatever is the vacancy,
you divide it 75-25.
75-25.
So let's come to the notification itself, 6/10/2006, page 21.
Yes, sir. In our affidavit, we have also given that.
Now, Mr. Nath.
The read petition copy. Annex 5 is there, but the copy is missing. I'll take your lordship to the same annex that page 53. In the affidavit of the secretary, we have annex. The third paragraph. Third paragraph of the middle.
Accordingly, a decision.
While we have been concerned about providing some opportunities of further growth to Anganwadi workers, it was never thought of the Anganwadi helpers in the same vein. It has therefore been felt that similar opportunities as in the case of Anganwadi workers should be provided to the Anganwadi helpers to motivate them to discharge their function more efficiently. Accordingly, a decision has been taken to reserve 25% of Anganwadi workers to be filled up from amongst the Anganwadi helpers who have put in minimum 10 years of satisfactory service and also possess the requisite qualification, age, etc., as laid down by the concerned state government, union territories for selection of Anganwadi workers.
Now read the next slide.
This will apply in respect of all existing vacancies of Anganwadi workers and new vacancies arising out in future. In the newly sanctioned Anganwadi centers, the guidelines issued by the ministry in the past that Anganwadi workers and helpers should be from same village would, however, have to be adhered to while giving effect to this new policy initiative. But following these guidelines, the notification has been prepared, has been issued by the
4/4/2013.
yes, 4/3/2013 at page 54 next page. This has taken care of all the criteria given in that. Kindly similar the guidelines. Serial number 9. Otherwise, others are as regard experience and
Eligibility
qualifications, eligibility guidelines has also got page 54. The promotion shall remain confined. Actually, this is upgradation confined to the Anganwadi centers of the same revenue village. And as such, the Anganwadi helpers of one revenue village or ward of a municipality or town committee cannot apply for promotion in the post that arises in center falling in a different revenue village or ward of a municipality or town committee. It shall be the responsibility of the CDPO to determine the vacancies and advertise them, calling for application from the eligible Anganwadi helpers with prior permission of the Director of Social Welfare.
Mr. Nat, is it your case that in terms of the communication dated 6/10/2006, stipulation made therein, you have regulated the manner in which that 25% post would be filled up. You're not concerned with 75 here.
No, we are not concerned.
75 will take its own course whenever it happens.
Yes.
And this is not under challenge.
This is not under challenge.
Yes, Mr. Constable. First question first.
Well,
Where is the advertisement? Page 13?
Yes.
Page 13, you are Asma,
Yes,
right?
yes.
Now, which is your village?
My village is 69 Shilghagri.
Silghagria, part 1.
Yes.
Now, which is the Anganwadi center, your Silgharia part 1, you are entitled to serial number 1. So that objection gone. Now tell me, these are all guidelines, right? These are this guideline at 6/10/2006 and a guideline at 4/3/2013.
Same speed and objective. Same speed and objective.
Got it. Now, where is the challenge to this?
Yes, that is the issue. Initially, the director filed an affidavit wherein they disputed that the 6/10/2006 is a policy decision. This is not a rule or resolution that cannot be considered.
No. We'll say 6 has its own application. And what I find is that following 6, government had regulated
That is why
its manner in which it will be done in 4/3.
Yes.
Now tell me what is there.
The affidavit filed with the director lordship.
The director, forget it. We have the affidavit of the commission secretary now.
Yes.
We'll follow that.
That is very specific that 25% should be formatted, 75% should be direct. This is very specific.
Then what more is there? We'll follow that.
Yes,
We'll ask them that
but
wherever they are doing this,
Yes,
they will do it strictly in accordance with.
That is why lordship.
the provisions of 4324
Yes,
and
Lordship, out of 21 vacancies, they gone for promotion 17 posts. And now they are with the Lordship claim that for 400 centers,
okay,
there should be 100.
okay. Now tell
Lordship,
me,
it should
now
be
tell me. Now, okay, okay.
vacancies.
We'll test your that argument.
Yes, yes.
We'll test your argument.
Yes.
The advertisement is at page 29.
Lordship. In my petition, Lordship.
Your petition 87,
There are two advertisements, Lordship. One is
12,
19, yes, Lordship. And another is
18.
12.
Hmm. Now here, you will be eligible for 69 number Kilgoria.
Yes, no, Lordship. Here in the petitioner is the SS qualified, Lordship. He
Forget
is,
it, forget it. You will be qualified for 69
no, Lordship,
Kilgoria.
He is not qualified. He is for fit for direct recruitment.
That's what I'm saying. That's what I'm saying. You're
Yes,
eligible to,
belongs to, yes, 69.
you're eligible to appear for
69.
Kilgoria.
Yes,
In this advertisement, 7 posts are advertised.
yes,
And subsequently, they have advertised another 5.
yes, yes.
So 12. So 25% would be
12 and 5, 17.
12. There is a further advertisement.
Yes.
Free advertisement.
Yes.
17. So what would be 1/3? What would be 1/3? It would be around 3 posts.
Yes.
Right?
Yes.
So 3 posts will go for direct recruitment. Oh,
No.
sorry, promotion. And rest 14 has to be for direct recruitment. Now, how will that be determined? Which post will be for promotion? Which post will be for direct recruitment?
That's another.
No, I'm here because you are only eligible for serial number 1 in 87. You're not eligible for any other post to apply if it is for direct recruitment.
In general, I can apply Lordship.
You cannot. You will have to be within that revenue village.
Yes.
And the only revenue village I find is serial number.
The survey area.
Survey area, sorry. For direct recruitment, survey area.
Survey.
Survey area.
Yes,
So you will only come at the best for 69.
What is
You have not. You come to page 29.
29. Lordship in the 29 of the
Writ petition.
Lordship, there is note in my petition, Lordship.
Okay. Sorry. You come to page 13.
13.
Yes.
So revenue village, serial number 1.
Yes.
Kilgoria is part 1, is your village.
Yes.
Let us say that that is also the coverage area of 69 number Anganwadi Center, Silgoria.
Yes.
You can apply only for this post. Other posts you cannot.
Yes.
Right? If it's a withholding.
Yes.
Now, who will determine whether this post will go for under that 3 or 14?
The authority will decide. The Lordship, the criteria, if there, Lordship, that will definitely go for a criteria, Lordship.
So, Mr. Nath, in the affidavit that you have filed of the, we'll ignore the affidavit of the director.
Yes.
We'll only consider the affidavit of the commission.
Yes, Honorable. Yes, only the secretary, because the Honorable Court has directed to clarify the stand of the government.
But another aspect of the matter is there. Both the advertisements were state. And in spite of that, they proceeded and they appointed the persons.
File a contempt.
Lordship, this court observation, Lordship kindly.
No, file a contempt. We will look into it. If they have violated our orders, we will look into it.
I am referring one order of this honorable court.
So, Mr. Nath, you are going by the cadastre, if I may use that word,
Yes,
of helpers under a ICDS projects. 25 you will reserve for
Yes.
upgradation, 75 you will go for.
Yes, that because the guidelines say the CDPO has to, CDPO has to.
22/5/2023. 22/5/2023.
22/5.
Yes, 23. There's observation of this order.
Contempt, file a contempt petition. File a contempt petition, we will deal with it.
22, 5.
We'll deal with it. Don't worry. Any orders our orders are violated, we'll not allow them to go scot-free. We will hold them. But for that, file an application. Okay. Yes, Mr. Bishop. What is your case?
My lord, the respondent authority, they want to. I am working.
So this is Bhawanipur ICDS.
Yes, my lord, different.
Different. This is a different ICDS.
I did not interfere, my lord. It was different.
Any affidavit filed here by the government?
Yes, my lord, they have filed their affidavit, my lord. In spite of the fact that you,
What is your case, Mr. Bishop?
my case is this, my lord. On my land, the center was established and I was working temporary as Anganwadi worker. In spite of giving advertisement for direct recruitment, they advertise for promotion to the helper, my lord. And I have challenged that advertisement, my lord. And there is a specific direction, my lord, by this court, my lord, to produce the record pertaining to the case of this writ petitioner and the next writ petitioner in the other matter.
Yes.
My lord, kindly come to page 43, my lord. The 8 posts were advertised to promote the helper to the post of work.
Including the post you have been holding. You are holding which post?
Majgaon.
Serial number? Page 43, serial number
Serial
Mazgaon.
number 5.
Mazgaon, there are 2.
My lord.
149 number Mazgaon, Dokhin. And 54 number Bomani Sari. Which one are you holding?
And challenge, my lord, number 6. Challenge Majgaon, number 6, my lord.
6.
Majgaon 149 number. Majgaon.
Serial number 6.
My lord, after taking my land, my lord. After taking my land, my lord, otherwise I have to file suit against them.
Any deed made for donation? Any deed for donation made? Then you close down that Anganwadi center. You close down that. If they don't appoint you, close down that Anganwadi center. Put something else. They'll find out land.
There is no question of regularization of an
That cannot
worker.
be. I've told Mr. Bishop before.
These are honorary service. In fact, Anganwadi workers and helpers are not in government service.
My lord, only one thing may be considered: how they calculate it, how they come to the conclusion that yes, this center will go to the direct recruitment or promotion.
That is what I was telling the Lanak
That's
Council.
the question. That has to be decided from the record matter.
You will not be disturbed till the process is complete. You have filed 2 cases.
No, my lord, I have filed one case in the
Shahida
other
Khatun.
matter, I am the respondent.
Where?
In his case.
Oh.
He's working as helper
In that revenue village.
my lord.
Please come. It's your right. It is your right to make me hear. And I'm here to hear.
My lord, I was appointed as an Anganwadi helper.
So your case is that if that post is allowed to be recruited in terms of the advertisement, then you also have a chance of
Yes,
getting
yes,
recruited. And that being one of the posts put to advertisement, so you have a right
Right.
to be considered.
Since I am rendered more than 10 years service.
Service and you have the
and I am
qualification.
eligible, I may be
You
considered.
comply with 4/3/2013 guidelines.
My
That's your case.
Yes, ma'am. I'm still working, man. And my lord, so far he is mid party, my lord. My friend Bushwa, my lord, they are claiming that they are still working as an Anganwadi worker. That is absolutely wrong. They were appointed temporarily for some period, for 90 days. There are no extension. And
The affidavit of the CDPO
my lord,
gives a contrary
Yes,
picture. CDPO
Yes,
says he is working.
and the land, my lord, both these petitioners are related persons, my lord.
So do one
Sister-in-law,
thing,
my
if you
lord.
get it,
Family, land is of same family. I am also entitled to some share of that land. my lord.
oh,
So based on that
so
land.
first thing you do one thing, file a
he
partition
can
suit.
claim
No,
exclusive-
file a partition suit, thereafter come back, we'll hear this
Yes, my
matter.
lord. Yes, my lord. But
Mr.
when we decided on guideline, man. this is the
Mr.
guideline.
Nat, we accept everything. We accept 4/3. We accept your decision to follow that. Now tell me, how will you identify 25 and 75?
But the guideline has given the authority.
Guideline says vacancies. If vacancies is to be applied, every advertisement, you will have to make that division.
The guideline gives the serial number 10.
Hmm.
It shall be the responsibility of the CDPO to determine the vacancies and advertise them, calling for application. So the
How?
So
There has to be a guideline. He cannot do it on his whims and caprices.
But the report in the other case which I have referred, that total are 400. 21 is in place already. That those records are available with the CDPO.
No, you give me a guideline. Because see, this will lead to a lot of, I understand. You go by cadastering, this code has no problem. You go by cadastering. But say you give the liberty to the CDPO to pick and choose. There will be 2 posts of Anganwadi worker. He will pick up one as promotion and he will pick up the other one as direct recruitment. So it may bring in certain sort of a personal discretion into being. That should not be. There should be a clarity how he will do it. He will either do it in a, say the date of vacancies arising. He will distribute it accordingly. 1, promotion. 2, direct recruit. 3, promotion. 4, direct recruit. At a stage, the promotion will stop. The rest will go for direct recruitment. There has to be something. How?
But what is the guideline they are following for
Identification of posts?
That lordship, I'll definitely.
You'll have to get that. That's the only thing. You give me a satisfactory guideline for identification. We will dismiss this petitions upholding your.
In the first item number 21, what I in item number 29, what I find out, all the posts which are lying vacant, the Anganwadi worker post lying vacant under that ICDS project, all posts at that particular stage he has advertised, because he has sent the report that these are the Anganwadi workers post, those are lying vacant. So the entire post he has advertised, because the still 79 is there.
But
even then the guideline I'll bring.
Because that will only take care of item number 29.
29.
Mr. There is a dispute now.
30 and 31 are different.
No, Mr. Bushwa and Mr. Sikdar will have a dispute.
Logical.
Because Mr. Sikdar, if that Mazgaon is taken up 6, then he comes in. And if that is taken out, Mr. Bushwa will be deprived of his chance to apply.
He's out.
He's out. Because he'll not be in a position to apply for any other post, given the nature of direct recruitment. So there has to be a definite process for selection.
But as regard the
Not selection, identification of the post.
I think that I got, I'll get the instruction. But in item number 30, the person has claimed that I must have a right because I have given some land.
We have told Mr. Bushu at the start that you don't have a right for regularization.
Regulation is, there is no concept.
But we don't want to foreclose his right for a direct recruitment.
To have a participation.
So that, again, this guideline 4.3 we are accepting.
Logic.
But how will you,
The CDPO will.
how will
identify-
that section, clause 10
I got that.
be regulated?
I got that.
I want a regulation for that.
I got that. But even in 2006, when the central government guideline has come, the language is because the Anganwadi, the ICDS projects, those are continuing, running. Because at that point of time, the guideline has come because they thought that the Anganwadi worker we have taken care of, we have given opportunity to them for upgradation.
No
not
problem.
To helpers.
Helpers also should be, because they are also
Those-
working for a very meager amount.
Those all are continuing at that point of time. Therefore, whenever the vacancy arose, that has to be counted to. fill
So
up the 25%.
what is it? See, there has to be a manner in which
Manner.
this clause 10 would be applied.
True.
The application of clause 10,
True.
that's all.
True. That I'll take. That I'll take.
Only on that. Otherwise,
I have
my subject to what you can show.
I have not only made prayer for promotion, but also applied and in person the advertisement.
Okay. My case is, my
Here-
view is that the 10.6 and 4.3 are not at violation. They are not at divergence. They are the same thing. Only my concern is clause 10 of 4.3, this discretion, how the CDPO should, because he must not be given a free hand, or an impression should not go
Mala.
that this post was identified because there is somebody close to him there. Anganwadi helper. Here he does not like this Anganwadi helper, so he has not done it.
It's an, in fact, the promotion thing will not come because the person, if a post is available, he will immediately not come. Because all other 2-3 persons, they will compete. There will be a selection process.
So not,
Logic.
we know when we are sitting there with the materials that would be available, who is coming or who is not coming. It will basically be a seniority thing. The criteria does not say how the recruitment is to be made.
Look.
It's only the eligibility criteria. Once you satisfy all those, it has to be gone on merit, on seniority.
From 3%.
It says scrutiny committee.
Logic.
It's not a selection committee.
A committee will ultimately.
Scrutiny.
Yes, sir.
That scrutinization would be of the eligibility criteria. Then whoever is senior most will get it. Heard. Heard the learned counsel for the parties at some length. Also, the learned counsel for the petitioners have made their submissions in the matter. Mr. Nutt, the submissions made of Mr. Nutt, learned senior government advocate, remains inconclusive, inasmuch as Mr. Nutt submits that he be given a week's time to receive instructions as to the manner in which the apportionment of vacancies of Anganwadi workers in the ratio of 75:25, that is for direct recruitment and promotion, shall be made, and the identification of posts in a particular ICDS purpose project for the said recruitment shall be made would be addressed by him on the next date of listing after receiving due instructions from the authorities.
Can I prefer, kindly add for implementation of 4/3/2013 notification?
I'm not putting it because I don't want to commit myself. They may have a better argument against that, so I don't want to foreclose that. It came to my mouth at the first instance, then I stopped it. So you can make your submissions, but this is the view of the court. We are upholding 4.3. but I want to know how the post identification will be.
Yes, that,
When?
that, that I'll please, Lord.
When?
Lordship has granted me 1 week time, Lord. Kindly give a date, Lord, on.
Yeah, I'll give you a date. When?
Lordship. Kindly take it up on 8, Lord.
8.
8, Lord.
Okay. Register to list this matter again on 8/8/2024 for further hearing.
Well, all the 3 cases will come?
All the
on
three.
this
Yes,
point.
exactly. Mr. Bishop, work on it. If you can find out something more, this is tentative view. But if there is nothing, I'll solidify subject to what Mr. Nat tells me about that identification of it. The compassionate appointment of the person.
Hello? আপনি করছেন
Robot. Voluntary पे आ जाओ हैं? Robot. Voluntary पे आ जाओ रे. Voluntary पे आ जाओ रे बा. Voluntary. Voluntary. कौन सा गाड़ी से कौन सा क्या नहीं?
31.
12/2019.
Okay, disposed of. Yes. What has happened?
Lordship, these matters were disposed of by coordinate bench of this honorable court, Lordship. Then the petitioner preferred an appeal, Lordship. The appeal was listed on 24/7/2024, Lordship.
This case or the other cases?
The similar cases.
Similar
Lordship.
cases.
Just
okay.
the other counsel for the petitioner, Lordship. So that appeal was about to get dismissed, was about to be dismissed, Lordship, but then the petitioner paid for filing a review, Lordship. So the petitioner has not yet filed a review, Lordship, but similar matters were listed today before the honorable bench of SK Medi, Lordship. So he has passed an order that let this matter be taken up after the review has been prepared by the.
It is stated at the bar that in similar matters, a coordinate bench of this court had passed orders rejecting the claim of the petitioners therein. However, it is contended that a review has been filed in the matter which is stated to be pending. Registry to list this matter after the registry to list this matter again after 4 weeks on a date.
The writ appeal number is 228.
No. 4 weeks. Let's see what happens.
Highly obliged.
Imran?
My lord, kindly give me 1 week time.
No.
My lord.
Can't. May 2014 matter.
Yes, your lordship. May I please, your lordship? I am going to be newly engaged in this case.
You be engaged.
What happened, your lordship?
Now tell me one thing.
Yes.
You are the employer. We are exonerating the railways. You pay.
No, your lordship, as per section 12, your lordship, the principal employer is the railway.
So they'll have to pay. You have no liability.
They can indemnify from me.
No. Why go for the short circuit route? We will directly now. You are before me. I'll tell you pay.
Your lordship.
Within a period of 2 months with interest.
You are against the order.
So you also admit that you have to pay, right? Finally, you have to pay.
It will be indemnified with the insurer, your lordship.
Insurer is not. Why did you then make a provision here? Insurer is not liable. Insurer is not liable for the penalty.
Your lordship may kindly. That's why I am seeking time, your lordship.
No, 2014 till 2014 till today.
Your lordship.
10 years.
Your lordship may kindly.
Okay, I'll give you time till tomorrow morning.
Tomorrow,
first matter. No, other than others, I'll dismiss it. This is not to be.
Let's do on Tuesday.
No, today, tomorrow at
Friday.
Friday we have kept a lot of.
Your lordship, Friday. Your lordship,
Friday, Mr. Let us. But this is the order.
Yes.
Final.
Heard
the Learner Council for the parties. Mr. S.C. Biswas has concluded his argument. However, the Learner Council for the respondent number 5.
5 to 9.
The submissions of respondent number 5 remains inconclusive. Accordingly, the registry to list this matter again on Friday as for further hearing. Apni by slip pothai dibo.
Obliged.
The grievance, full stop, heard Mr. Jay Barbiya, Learner Council for the petitioner, and also Mr. Public Enterprises, you will be appearing?
They have a separate council, lordship.
None appears for the respondent number. Mr. S.K. Goswami appears for the respondent number 4 and 5. Mr. P. Naik appears for the respondent number 3. However, no one has entered appearance for the respondent number 1 and 2. Okay, Mr. A. Kolita appears for respond numbers 1 and 2, Upar mein likh dena, 1 and 2, serial likhna. The petitioner, by way of instituting the present proceedings, has presented a grievance with regard to the manner in which the VRS benefits as due to him were so computed by the respondent authorities. Wide and order dated 6/1/2015. So, the petitioner herein contends that in terms of a notification dated 10/6/2004, the petitioner who had opted for voluntary retirement was to be authorized his dues in the following manner. A to A. However, the said notification dated 10/6/2004 was subsequently amended by another notification dated 15/2/2006, wherein the terms of the calculation of wherein the manner of calculation of the voluntary retirement dues were so modified. So, it is to be noted that the petition is being aggrieved by the subsequent notification dated 15/2/2006 had instituted proceedings before this court in WPC number dash so and so. WPC number 5531 of 2010. So this court consider the issues arising in this writ petition as filed by the petitioner hearing, along with other analogous matters, and wide order dated 11/12/2014 was pleased to dispose of the same with the following observations and directions. Page 56 B to B. So it is seen that the respondent numbers respondent number 4 being aggrieved by the directions as passed by the coordinate bench of this court, while they said order dated 11/12/2014 had instituted a writ appeal being writ appeal number 159 before this 159/2015 before this court. So they said a writ appeal was taken up for consideration, and this court wide order dated 18/4/2017 proceeded to reject the challenge as presented to the directions passed by the learned single judge. Full stop. The respondent number 4 thereafter assailed the division order of the division bench by instituting proceedings before the Honorable Supreme Court of India. However, they said proceedings on consideration were dismissed wide and order dated 7/11/2023. So, in view of the above position, the claim of the petitioner hearing for being authorized his VRS dues in terms of the notification dated 10/6/2004 stands upheld. Accordingly, so in view of the above, accordingly, the respondents, more particularly the respondents number 2 and 3, are hereby directed to compute the VRS dues of the petitioner strictly in accordance with the notification dated 10/6/2004 and to release the same to him after deducting the amounts already released to the petitioner in this connection. Also, they said computation and release of the VRS dues of the petitioner be so made and released within a period of 3 months from the date of receipt of a certified copy of this order. With the above observations and directions, the petition stands disposed of. Yes, where is Mr. Gogoi? B. Gogoi. Get hold of Mr. B. Gogoi. Next day. Habib, Mr. Islam, what is the current position with regard to this PNRD employees
My lord.
who don't have, who have more than 10 years but less than 20 years but do not figure in that 354 list?
They are entitled to pension.
They are entitled. There were some orders passed by this court. You have a copy of.
My lord, those who have completed more than 33 years, they have entitled to full pension. My lord.
No, that after provincialization, 10 to
My lord.
20, that calculation was taken.
Yes.
There were some orders passed by my Lord Justice Bujar Barua,
Yes, Your
followed by some other coordinate benches also.
Kindly take up item number 48 of this list today, my lord.
Oh, 48.
Item 48.
Somehow I forgot what exactly happened.
My lord, in this case, my lord, and it pays my lord 32.
Yes, sir. I can have a list.
30?
32.
WPC 1950?
1950.
32 is some.
My lord, is it my lord?
Well, he's got similar matters pending before this honorable court. So he's taking up his matters as well.
They are in.
Huh?
Item numbers 48 to 51.
I'm considering 48 only.
My lord.
33 is something.
Then your lordship come to page, my lord, page, my lord, 70.
70.
My lord. The judgment of this single bench of this honorable court, my lord.
That is what I want.
My lord, page,
My Lord Justice, this is the one. I want.
Page, my lord, 75. Operating. Para 11 and 12, my lord. Whatever, my lord, in this case, my lord, petitioner husband had rendered more than 35 years. But his service was deducted and my lord calculated
Okay.
the date of.
They have complied with that also.
My lord, yet to be fully complied, my lord.
No.
They have paid pension, but my lord, the lower pension has been paid. My lord.
Page 78, that order 2323, they have complied with the orders that you are entitled to pension.
Yes, yes, my lord.
Here, I am only in that stage.
My lord,
In the present case, I am only in the case of entitlement of pension.
my lord.
So we will pass an order in that case, disposing it off in following the order of my Lord Justice Bujurua here.
My lord.
And thereafter, let them, and in your case, what further consideration is to be made, we'll make it.
My lord.
Okay. Any objection?
Let the principal secretary process the pension papers and forward it to the AG's office, Accountant General's office.
But
Need a power proposal. Pass on my.
yes, your name?
My lord, I was initially appointed
No, your name?
A.N.
Huh?
A.N.
A.N. Ahmed. Heard Mr. A.N. Ahmed, London Counsel for the petitioner, and also Mr. Your Handic, P. Handic, London Standing Counsel, Panchayat and Rural Development Department. Also, the petitioner herein has raised a grievance with regard to the inaction on the part of the respondent authorities in authorizing to him his pension and pensionary benefits on his retirement as a provincialized provincialized panchayat employee. So the petitioner herein was initially recruited as a secretary was initially engaged as a secretary under the in the Digas primary panchayat under Mangoldoi Muhuma Parishad. So thereafter, the services of the petitioner was provincialized by notification dated 16/11/1991 with effect from 1/10/90 was initially engaged with effect from 1/1/59 as secretary. So it is contended that the petitioner, on attaining the age of retired from his services with effect from 31/1/1998, on attaining the age of superannuation, as secretary of Pathorigat Gaon Panchayat under Jila Porishad, under Dorong Jila Porishad, paragraph 2 mein hai, huh? So the petitioner herein contends that after his retirement, so occasioning in the year 1998, he has been approaching the respondent authorities for release of his pension and pensionary benefits. However, the respondent authorities, on arriving at a conclusion that the petitioner herein had not completed 20 years of service, he would not be entitled to receive the pension. It is the further contention of the petitioners herein that the government in the Panchayat and Rural Development Department had granted relaxation to provincialized Panchayat employees who had completed 10 years of service but had not completed 20 years of service as a provincialized employee. However, the name of the petitioner does not figure in the list of 354 employees who were extended with the said relaxation. So accordingly, the petitioner, who had rendered around 17 years, how much years? 17 years something.
19 years.
17 years of service. 17 years of service after provincialization in the department, not being authorized his due pension and pension benefits, has instituted the present proceedings. Also, Mr. P. Handick, Learned Counsel for the petitioner, has submitted that the matter would require a detailed consideration by the departmental authorities, and accordingly this court would be pleased to refer the matter to direct the principal secretary, Panchayat and Rural Development Department, to consider the claim of the petitioner and pass appropriate orders. Also, the above submissions of the petitioners have been noticed. Also, it has been brought to the notice of this court that similar issue as arising in the preceding proceedings had also arisen in the proceedings of WPC number 361 of 2022, bracket mein, Saribun Nessa Majumdar versus State of Assam and others. And therein, this court, upon considering the claims, the contentions as made by the parties and also on perusal of the provisions of law holding the field, had come to a conclusion that the husband of the petitioner therein, although not had completed 20 years of service, considering the total length of service rendered by him in the Panchayat institutions, in the Panchayati Raj institution, would be entitled to pension and pensionary benefits, and accordingly proceeded to dispose of the said writ petition requiring the departmental authorities to take note of the notification dated 7/3/2011, which refers to the total length of service total length of service of an employee and total length of service, and pass appropriate orders. So the relevant observations and directions of the coordinate bench in the case of, as passed in the case of Saribun Nessa Majumdar bracketed Supra, being relevant to the present issues arising in the present proceedings, is quoted here in below. Para 3. Oh. Ali, how many years of service you have rendered after provincialization? After provincialization, how many years of service?
10 years.
Huh?
10 years.
19.
1991 provincialized, 110/1991, and retired on, my lord,
1998.
1991, 110/1991 provincialized.
He retired when?
Retired on 30/11/2000.
30.
Almost 10 years.
Nine.
9 years.
9 years.
9 years.
Oh.
Less than 10.
My lord.
Then he won't be eligible, my lord.
Appointed employees, my lord. That to the
33
length
years.
of, sorry, from the date when he
Nine.
appointed in the service.
I got
of
it. I got it.
Adjournment.
Also.
As per
Well,
Fazlur.
there's a small catch here. There's a small catch here, Millet. Subsequent judgments of the Honorable Apex Court, I have a copy of such an order. It states that his initial appointment was in the year 1962.
His 57.
30th of April 1962, Millet, date of joining. Petitioners.
Oh, sorry. Sabirun Nessa Marias. Sorry.
252 of 2017, my lord.
Huh.
His initial date of joining was 30th of April 1962. Provincialization takes place, my lord, in the year 1991. Subsequent to that, my lord, in the year 93, posts were created and employees like the petitioner herein were accommodated against those sanctioned posts. So now, my lord, the judgment of the Apex Court states that their date of entry into service will be counted from the date of regularization. And the previous-
Mr. Have you got the Provincialization Act with you? 1991.
I have the judgment also.
No. I have the Provincialization Act.
I have.
You have the My Lord Justice Roy's judgment.
It is Emma Shah.
No. The judgment in the present case of My Lord Justice Roy sitting in the division bench. If you have that, if you come to that, it's there in your case, Mr. Yes, it's here.
Page 30.
Wait.
But this would override all the Supreme Court judgment. It will override the principles that were laid down in the division bench judgment in Fazle Rabbi. Fazle Rabbi said that the qualifying period would be counted from the date of the initial appointment. Whereas this Supreme Court judgment, which has been subsequently passed, it states that the qualifying service prior to regularization won't be counted.
This is not regularization, it's
My lord, I have the
provincialization.
regulation orders here. The
And
Fazle-
herein the appointed day has been clearly reflected. Okay, you be here. We'll take it up along with Mr. Islam's items. Be here for some time. I was dictating from the wrong file. We'll have it. Mr. Islam, get me a copy of that Provincialization Act, and the judgment of My Lord Justice Roy is available. So no problem. We'll clarify that issue. Mr. Counsel, you give me your judgments, whatever it is there. We'll call it up. Let me
As a
call it up.
relevant,
When it is called up, you give me. We'll consider that and then we'll pass up order. We'll take into note all. Iman? Mr. Gogoi. If he is bad,
Yes.
tell he is bad.
Well,
But
the-
why this?
Yes.
Why is this
the-
suspended conclusion?
The entire records are with the CM.
We can't help it. Then why are you troubling him? You can't have conclusions in air.
My lord. But my lord, from the inquiry report, what you were.
Be that as it may, the final conclusion is that we can't take a final conclusion because his records are with the CM Vigilance.
But my lord, subsequently, what happened, my lord, that despite my various communication, nothing has come up.
So we'll have to put him back then.
But it presently, whether he's continuing.
He
or
is not continuing
He's not continuing that.
because you have not permitted him to continue. And if you can come to a definite, if you can't come to a definite conclusion, why? Deal with him in this manner.
Lordship. Otherwise, my lord, that.
Nothing is here. Your inquiry report is also
He says, my lord,
subject
there was
to
no
that.
advertisement, yes.
Huh?
There was no advertisement, no select list.
We
Even,
all,
my lord,
we get it.
After his joining in Dibrugarh, after his
We
initial
get
appointment.
everything. He was transferred. He does not.
Final conclusion is.
Final conclusion you can't take. You have not taken. How can we hold that? That is the conclusion.
Lordship will indicate in the order as the last sentence on Wednesday next month. As a last sentence. Whether anything.
Mr. B. Gogoi, Learned Counsel. In continuation of the prayers made by him on the earlier dates of listing, submits that he be given a week's time to receive instructions in the matter as to whether materials are available on record to conclude that the petitioner hearing was not appointed in the manner required and his appointment is illegal, is ab initio illegal, full stop. The prayer of the petitioner, the prayer of Mr. B. Gogoi is accepted. However, it is provided that such an adjournment is made for the last time and no further adjournment in this connection would be made. So it is to be noted that the materials brought on record by the respondent authorities, from the materials brought on record by the respondent authorities, it cannot be concluded finally that the appointment of the petitioner herein is illegal. So in the event no instruction is forthcoming on the next date of listing, this court would proceed to pass appropriate orders considering the materials brought on record.
Otherwise, we have concluded the second phase by the department. Lordship is aware of that.
No, but
He somehow was left out in the second phase.
you have put him in a question mark.
Yes, sir.
He is bad. However, we can't say because the
records are.
You get that?
Yes, yes.
That's why I'm giving you a little bit longer rope because the nature of allegations.
Yes.
If not, we will direct.
What's the way?
Online.
What's it?
Yes, Mr. Bora.
Date may be fixed.
208. Mr. Gogoi, 20th. You take your time. 20th.
Lordship, section 6(4), Lordship, I also mentioned in para 10 of my petition. So, may I read?
It is one and foreigners law.
Lordship, this is the book I may read also. It's Citizenship Act, section 6, A, subsection 4. A person registered under subsection 3 shall have, as from the date of which he has been detected to be a foreigner until the expiry of the period of 10 years on the same rights and obligations as a citizen of India, including the right to obtain a passport under Passports Act 1967 and the obligation connected, but shall not be entitled to have his name included in the electoral roll for any assembly and parliamentary constituency at any time before the expiry of the said period. A person registered under subsection 3 be deemed to be a citizen of India for all purposes as from the date of expiry of 10 years from the date on which he has been detected to be a foreigner.
Okay, come to 6(4). You read the original 6(4). Or you can read
Lordship, may I pray? Lordship, now initially suppose I am in.
No. I'm with you only. With you only.
Yes.
What you are trying to say, I'm just clarifying.
Yes.
6(4).
Yes.
A person registered under subsection 3.
Three shall have as from.
No. Shall have. Stop. As from the date on which he has been detected to be a foreigner and till the expiry of a period of 10 years from that date, the same rights and obligation as a citizen of India, including the right to obtain a passport under the Passport Act and the obligations connected therein, but shall not be entitled to have his name included in any electoral roll for any assembly or so-and-so. A person registered under subsection 3 shall be deemed to be a citizen of India for all purposes as from the date of expiry of a period of 10 years from the date on which he has been detected to be a foreigner. So you become an Indian citizen after the detection. Period before that, you are a foreigner.
Yes, Lordship. Now, Lordship,
Lordship, may
What error is there?
may I, one thing I wanted to, firstly, after 5.5 years, it has come, I don't know about the whereabouts of my client. Secondly,
Need not be. You have the file with you, that is enough.
Lordship, the second thing is a person, suppose he is initially illegal, subsequently, he is
Subsequently
illegally
from the, no,
cured
here,
on-
Mr. Bora, we are not considering whether the declaration of you as an Indian or a foreigner is right, wrong, whatever it is. We are only considering whether on the date you were appointed in ASTC, whether you can be deemed to be an Indian citizen. The provisions of law is very clear. 6(4) and 6(3). You will be an Indian citizen after 10 years from the date of detection. Your date of detection is much after the date of your appointment.
2004, Lordship. So only thing, Lordship, suppose, Lordship, one, I am initially, suppose, let us presume that initially I am an illegal. Subsequently, that defect has been.
You show me that subsequent rectification, registration makes you an Indian citizen from day one.
No, on the date of now I am retired. Only thing remains is my pension, Lordship. I am arguing on equity only.
Equity for a Indian citizen, I can understand.
No.
But equity for a foreigner,
No,
I don't
no.
understand.
No, Lordship, just on the date of my retirement, I was a citizen of India.
We need not be. What we are concerned here is with your entry into service. That is what is being dealt with.
No, I am only on my entitlement to pension. Lordship.
You are not entitled. Even if we don't set aside this order, how will you be entitled? Now I'll have to set aside this penalty imposed upon you.
The authorities did not consider this provision, firstly, and secondly, suppose from 2014, I am a citizen for all purposes. On 2018, I retired. On that day, I am an Indian citizen.
2014 onwards, if you have got any appointment, any lease, anything, benevolent act of the government, that will be protected. But this will not be.
Oh, Lordship, subsequently, I want to argue that it is cured subsequently on the.
Just show me from the provisions of the Citizenship Act that the subsequent registration would have the effect of regularizing your stay from the date you came to the country. Because you were declared as a foreigner, mind you, by the IMDT court or by the Foreigners Tribunal. Thereafter, finding you having come within that opening given,
yes,
they had provided you to register. You see, you have been declared as a foreigner.
Yes,
Then
I have seen that, Lordship, just and the whole departmental proceedings.
and accordingly, both the opposite parties are declared as foreigners. Then you come up before this court. This court provides that, okay, you are a foreigner, but now we permit you to register prospectively. Then
Page 17 is the original order. Page 19, page 20 is the order of this
order of this court.
Now, Lordship, Lordship will give me 2 days to examine this issue, whether I can get any similar judgment. Only on equity, Lordship, I am.
Equity will not come in, at least before this court, on discount. I am online. I am making that statement knowingly. It will not come. Foreigner will have no equity because you have prevented an Indian citizen from occupying that post.
And moreover, whether there is any, because
and they have dealt with the matter in a very nice manner. Very reasonable conclusions have been drawn. Friday, on the prayer of Mr. D.P. Bora, who his submissions remain inconclusive, list this matter again on Friday for further hearing.
Deeply obliged.
But show me from the provisions of law that your registration is retrospectively applicable. I will be with you. I'll set aside everything.
Lordship, I will try.
Mr. Rabha, how can we help you here?
This morning I could not be present, my lord, out of.
No, it's okay. How can we help you? Because
kindly give me 1 day time, my lord. Have it on Friday, my lord.
Friday, same prayer. But Friday don't adjourn. We have read the brief. I don't want to read it again. Yes, madam. Have you gone through the judgment? Devabrata. And just for your information, today morning, 2 cases, 2010, I have dismissed.
It's
I know about
2004.
it because earlier also expressed a view. That is why.
And this is the view of the division bench. Now, division bench, my orders were tested. It was rejected. So we'll close it. Heard Miss MS. Baki tum musse le lena. Heard MS MD, Learned Counsel for the petition, and also heard Mr. J.K. Goswami, Learned Counsel, Additional Senior Government Advocate, appearing for the respondents. The petitioner in the present proceedings has raised a grievance with regard to the non-consideration of a case for appointment on compassionate grounds. Compassionate grounds in pursuance to the death of her family, of her father, who was a government employee. Also, as projected in the writ petition, the father of the petitioner Sokro Singh Narzari, while working as a grade 4 employee at Serfanguri IB, page para 2 mein, under the respondent number 6, had died in harness on 31/10/2004. So it is contended that the petitioner herein thereafter submitted an application on 7/3/2005 in the prescribed format for consideration of his case on compassionate grounds in terms of the scheme as holding the field at that relevant point of time. It is further contended that the name of the petitioner was considered by the jurisdictional district level committee in its meeting held on
11/10/2006.
Where is your consideration?
Page 26. Look.
District level lordship, it is 21/12/2006.
Page 26.
11/10/2006.
Yes.
No, where is your name being considered?
Page.
Also, was considered by the jurisdictional so-and-so in its meeting held on 11/10/2006 and accordingly, and therein on noticing that the number of vacant posts as available, they not permitting consideration of any case of any applicant for appointment on compassionate grounds, comma, the case of the petitioner was recommended for absorption in the parent or any other department if so permissible. Full stop. It is contended by the petitioner hearing that thereafter no consideration, right, Ms. Dev?
Yes, Lordship.
No. Thereafter, there was no,
State level committee, Lordship.
but no consideration made.
Consideration, nothing. It has been
It was considered that it was contended by the petitioner that thereafter there was no consideration made in his case and the matter remained pending. So it is to be noted that the petitioner hearing, the father of the petitioner hearing had died in harness on 31/10/2004 and thereafter, although the petitioner's case was so petitioner on making an the petitioner's case basing on the application made by him was considered by the jurisdictional district level committee in its meeting held on 11/10/2006. Comma, no final, no order was issued towards appointing the petitioner on compassionate grounds. Also, it is seen that the petitioner after 2000, it is in the writ petition, the petitioner has not explained the delay, so occasioning in preferring the present writ petition in as much as after 2006, it is not highlighted as to how the petitioner had pursued the present proceedings. Also, बाकी ये जो दिया है अभी उसको उससे कॉपी कर देना. Dismissal. In view of the above, the writ petition, we find the writ petition to be devoid of any. Oh, last का paragraph है उसमें. Disposed of. Sorry. Next step.
Next compassion on ground case.
Huh?
Next compassion on ground case.
It hurts here also, but I'm bound by certain principles of law. Can't help it. If I reject 2010, how can I allow 2004?
Yes.
And that judgment of Debarment Tiwari is very clear. What happened?
But,
that anger is missing. What happened today? I'm not feeling well or something. That force is missing today. Did not enjoy it today.
Yes, policy decision of the government different from everywhere, and central government is.
You are keeping well, I suppose. That force which is normally attached is not there.
My case is weak. That is why.
Oh, that is no.
17.
Wait, please, Lordship. Lordship, in this matter, Lordship asked me to get instructions, Lordship. Here we basically, my lord, the cause list, my lord, our names are
On the prayer of Mr. A. Fukan,
Wednesday
this matter again on Friday.
My lord, Wednesday we'll get our instructions.
I'll ask your secretary to be here
But,
Friday if you have any problem.
my lord, actually,
This not even for a single day, and I'll be imposing interest on you for the delayed payment.
my lord,
Friday, Mr. Fukan, if you can get it. Others will call you up secretary. We will not permit a disabled lady to be without any means of livelihood. We will not. At least this court will not.
my lord, we also, my lord, will cooperate, my lord.
Why you have not cooperated? You have done
Because we
nothing.
have not got the petition.
You are asking for a death certificate. Can't you make an inquiry and find out? She has submitted the death certificate. Thereafter also you don't.
My lord,
In
I've
your
sent it-
affidavit,
I've
you
sent
said
it now.
we don't have a death certificate. On Mr. A. Fukan,
My lord, that
on the
affidavit is
next
filed
date
by
of listing,
the government advocate, my lord. I have not filed it, my lord.
on the next date of listing shall receive instructions as to the status with regard to the proposal for release of family pension. to
I'm
the
appealing for
petitioner.
three, your lord.
You are the man who should do it. Who is
My
the
lord,
person who should do it?
It has come to us, my lord, but
Then-
we were not the councils, my lord. We just didn't give a.
Forget the councils. I only know the respondents. Councils come and go. Judges come and go. Respondents remain the same.
Sometime I'll get the
No,
instructions.
Friday.
Be applies.
In the event it is the instructions are sought for is not forthcoming, the secretary to the government of Assam, what is it? General Administration Department shall remain present in person. And now I get to continue. Last one. One more chance. Or Monday I'll call him. Keep it parted. Madam, wait for a day.
If you applies, my lord.
Yes. Come over now.
Yes, Lordship. I have mentioned one disposed of matter.
Lordship, there was a committee formed. They have stated in their petition also, paragraph number 5, a committee was formed and that committee found only 11 numbers of master roll workers were engaged after 1/4/1993.
After they say they were appointed after 1/4/93.
Yes, Lordship.
So where is that report?
The report is not here, Lordship.
You
There-
get the report.
Okay, Lordship. I can get.
We'll dismiss the petition then. Where their cases also considered by that committee.
Yes, Lordship. That committee have gone through all the.
Tomorrow, 2 p.m. You get your. tomorrow, 2 p.m. Kali, 2000. If the committee has gone through it, madam, and your case was not found eligible, we'll dismiss your writ petition.
So they have stated in their petition also this.
How will they get that? You will have to get it. Is it a very public secret document? Then produce it. Tomorrow, 2 p.m.
Okay.
But if I find that their names are not there, then you will be in.
That only the report is there that after 1493, only 11 numbers are there.
Get me that report.
Okay, Lordship.
And also take an instruction whether their cases were also placed before that committee.
Okay.
Committee will have to go through everything. Then
Lordship, they must file an affidavit.
why should they? What is the necessity of an affidavit? It's only that information. And when Mr. Sharma is producing it, it's like the Water Resources Department producing it before me. Do you disbelieve him? Yeah. Tomorrow, 2 p.m. Kali 2000.
May I please, your Lordship? Lordship, in this matter, I need 2 more weeks, my lord, because the service book of the petitioner, my lord, was called from the video, my lord, which has not been received yet. Therefore, we need some more time, my lord. The temporary appointment, my lord. When the post was regularized, that was asked for.
Okay.
That
LDA promoted as UDA, but no regularization
Yes.
anywhere.
Yes.
Yes, Mr. Chaudhary.
Just I am, my lord.
You show me. It's your case. You show me.
My lord, that
Last day you were not here, I suppose.
Yes.
Somebody else was here.
last I was not there.
That is why we
Only
used to
that, my
pass.
lord, I am, this is my lord, that's on our part, my lord, we could not furnish the, my lord, regulation order.
Papa,
Page-
give it to me.
Lordship, page 20
Huh.
is an order,
Hmm.
where, my lord, it was mentioned about a memorandum, office memorandum, my lord. Perhaps by that, my lord, some regulation order was, I have instructed my client.
19.3, this office memorandum is not pertaining to this.
No,
It
my
is
lord, this is
pertaining
for
to some reservation.
In pursuance to the government office memorandum number so and so, 19/3/2004. And on the case, next one is, my lord, recommendation of selection, my lord. First part, perhaps something is done.
As prayed for by Mr. S. Dutta, Learned, Standing Counsel, PNRD Department, raised it to list this matter again on 21/8/2024.
Obligement.
It is the instructions, the directions as passed by this court by order dated 28/6/2024 shall be complied with by the on the next date of listing by the respondent authorities.
33.
May I please, your Lordship? Lordship, all the respondents did not file affidavit in.
Lordship, we have already made the payments, Lordship. The claim of the petitioner is on para 3 of the writ petition, Lordship. There was some balance of the arrears salary, Lordship. We have already paid. This is the breakup of the balance.
And what about, they are regular employees? Madam, you are regular employees. You have got your pension.
Here, only for, except respondent number, sorry, petitioner number 3
They have
and 7.
retired already.
Till now.
But other writ petitioners, have they got their pension and pensionary benefits? No.
Para 3 of the writ petition is the amount, Lordship, the balance amount. Petitioner number 1, Lordship, 39,57,652. The pleadings, they have admitted that we have given them 37,64,400.
Okay, what about their pension?
That instruction, Lordship, I have to take.
Then-
Might be they have got the pension, Lordship. They have retired
Take it.
2021.
When?
Yes.
Tomorrow,
Lordship,
day after?
No, Lordship, next week, please, Lordship.
Next week, okay. On the prayer of Miss R. Boral, Learned Counsel for the petition, for the Standing Counsel, Agriculture Department, raised it to list this matter again on 21/8/2024, on which date Miss the Learned Standing Counsel shall, Miss Bora shall place before this court, shall receive instructions as to whether the pension and pensionary benefits of the petitioners who have already retired have been finalized and released to them.
Lordship, they have not paid for their, Lordship, in the prior portion, Lordship, they have only claimed for the arrears element that we have already paid. Lordship. They have not claimed for any retirement benefits. Page 25.
And why they will not get all retirement benefits as has been given to government employees as per high. My eyes are still functional.
Can you fix the date?
21/8.
Problem.
34.
Yes, Mr. Nath.
But the issue involved in this matter is my
Huh?
issue involved in this
Huh.
matter is my lord. The petition was placed under suspension pending royal department proceeding. That has been drawn up, my lord. Ultimately, pursuant to the order of the honorable court, my lord, they reinstated me. But in the Indian order, they write the period during the suspension shall not be treated on duty for the purpose of pension. Number one. Number two, 75%, my lord, sufficient allowance was not granted, and also the promotional matters, my lord. Now, Lordship, kindly see the page number.
Where is that impute order?
My lord, page number 43. 41 stars.
You have retired.
Chapter 10. No, I'm not retired. In future, that's it, my lord. Page 41 stars in chapter 10, my lord. Court's order, my honorable court's order. Hierarchy.
Huh? What is this, madam? What is this?
Lordship, in compliance of the order.
Forget the orders. What is this order from where you get the power to determine how the period of suspension would be done? Violation of 54B before you complete the proceedings. Proceedings completed.
No proceeding was done. Nothing was done.
I have filed my affidavit, Lordship.
What is your stand there?
In compliance of.
And you have been given 75% now.
Yes.
They passed the order, but even last night I spoke to my client. He has not received it yet.
No, you will get it now within a week.
Also, he has reinstated, Lordship.
Yes, madam. Suspension order of 2006, right?
Right.
No proceedings have been drawn.
No, Lordship.
This is 2024. Can you draw a proceeding now?
The chapter is closed now by now.
Gone. So give him the full benefit of the period of suspension because you have not drawn up. Mr. Nath, you make a prayer for that. Full pay.
Full pay, my lord, number one.
Silent in our
And the other thing is, my lord.
This C will go.
Yes. Second point is, my lord. During the last few years, my lord, the similarly doctors are there with me. Promotion has been made, my lord. So that constitutional promotion is concerned. Let them take the view. I have made prayer in my petition also. Because
No, we will do it like this. We will have this matter again on Monday.
Tuesday, Lordship.
Tuesday.
Tuesday.
But by Tuesday, in terms of your speaking order, the money must be credited to his account. In terms of your speaking order. On Tuesday, we will dispose of this writ petition, setting aside your clause C.
Yes.
And holding that no departmental proceeding having been so instated, the suspension period for last around how many? 18 years. Suspension period, we will hold that it is of no consequence. He will be entitled to full salary for that period. Now that period having been regularized,
Yes.
your any objection that he did not have the 5 years, 6 years, 7 years service will go. He will have continuous service. Then we will direct him to submit an application before you for considering his case for promotion, because now that break or the non-period of service, if
This
any,
obstruction.
will go. Miss A. Devi, Learned Counsel.
B. Bora.
A. B. Bora, Learned Counsel for the Learned Standing
Department.
Council, Health and Family Welfare Department has submitted that the respondent authorities by way of an order dated 24/5/2023 had directed for release of the subsistence allowance to the petitioner with effect from
2516.
2/8/2006
Yes, sir.
at the rate of 75% of the last basic pay as drawn by him. So, however, Mr. M. Nath on senior counsel appearing for the petition on instruction has submitted that the said amount has not been credited to the account of the petitioner. So, accordingly, this court directs the respondent authorities, more particularly the Secretary to the Government of Assam Health and Family Welfare Department, to ensure that the subsistence allowance in terms of the amount due to the petitioner as subsistence allowance in terms of the order dated 24/5/2023 be credited to his account within a period of 15 days from today. Also, the Ms. Bora, Learned Standing Council Secretary, shall on the next date of listing place before this court a compliance report in terms of the directions passed here in above. So, on the next date of listing, this court would consider the further submissions as advanced by the parties to the proceedings today. So, registry to list this matter again after 2 weeks, Diana. 2 weeks, issue. Ajit 31st. 1. 2. On 19/8.
My lord, I was just thinking, your lordship will not say 19. That is the only 19 that I've got a case in Shillong.
Okay, why not? 21/8.
Any day, my lord.
21/8/2024 for further hearing.
My lord.
On that day, we will pass the
Okay, my lord.
consequential. But first, get your money.
Otherwise also, rule 21 of the pension rules staring at her, my lord. 21 pension rules.
No, that occasion will not come in
No, not
because you're no proceeding, neither criminal
That's
or
what.
civil.
No judicial proceeding, nothing is there.
And Ms. Bora, you take your instruction. I'll pass orders. After 18 years, you have not done anything. Will not permit you to do anything further.
Nice, boss. Published.
35.
Thank you, the lordship.
Hmm.
Lordship, waiting for setting aside and call the select list matter. That is annexure. That is type copy is annexure 13, page 56, my lord. The thing is that the petitioner.
Who is for the private respondent? You are.
The petitioner is working temporarily as an Anganwadi helper from 2013, my lord.
Hmm.
Thereafter, an advertisement was issued, my lord, on 19/12/2021.
Where?
Annexure 11, page 46, my lord. And accordingly, the petitioner has submitted his application form with all relevant document. But she was not called for interview. But in the advertisement in column 18, where it was clearly stated that according to the government rule, the candidate will be selected only on oral interview. But she was not called for interview, but no list was, no merit list was published, and subsequently select list was not published but hang in a
You are interested for the post of helper.
helper. I am working since 2013 from temporarily, my lord. That is all.
Okay, then what happened?
Then I have applied for the post when the advertisement was published, but with all relevant documents. But I was not called for interview, and subsequently select list was published where the respondent number 6 was selected. Who is the president of that Anganwadi center?
Who is not?
Who is the president? At that time, the
Respondent number 6 was the president of that Anganwadi center, my lord.
President. Lady,
Lady.
what is respondent number?
Dekar. The serial number 12 of the select list, page 56.
She knows better.
So my prayer is, as I am submitted all the.
Yes, madam, what is your stand?
Lordship, we have filed our affidavit, Lordship, and of the running page number 61 of our affidavit, Lordship.
Pritisha Kolita.
Lordship.
Yes. There's a headlines regarding so.
Point number 5, Lordship.
Yes.
Point number 6, Lordship. The last part.
Vexo said notification.
Strictly on the basis of marks obtained in HS examination and selection of candidate of Anganwadi helper shall be made strictly on the basis of marks obtained in SSLC examination, Lordship. And Lordship, this is our comparative statement, Lordship.
In case of class 9 pass so selection shall be made on the basis of marks obtained. You should selection committee will verify the education the pedestal of the.
So the selection should be.
Where is the comparative statement? The petitioner herein is class 10 pass. HS pass. And the private respondent?
Both the same, Lordship, but the
HS.
obtained
HS.
HSLC, Lordship. The second one is the respondent number 6 and the first one.
Mrinalini Deka.
Yes.
And you are?
Sondana.
Sondana Das.
There is a difference of 2%, Lordship. 2 points continuously working.
Now you said that there was an oral interview.
Yes.
Where is it? From where are you saying this?
It is an advertisement where column 18. Serial number 18, where it was stated according to the government rule that candidate will be selected only on oral interview. But she was not called for an interview.
Here there is no oral interview. It was only on the basis of marks.
But
yes, madam, how do you, what is the procedure? You said it is there in the advertisement where? Did you file a reply to this? Yes, you have filed.
I have filed a reply.
Yes, page, this is you.
Lordship.
Madam, any inconsistency in that?
There is only 2 marks less than marks obtained as per education qualification. The petition.
You have also said in your reply that it should be based on the marks obtained in the HS examination. And for the helper, HSLC, HSM. And they have done it. What mistake have they done?
No, my lord. HSL by submitting, but the respondent did not call for the interview.
Interview not required because they have done the assessment on the basis of the marks.
But there is a provision, my lord.
Forget it. What? There is no marks for oral interview. Fine. You have been, that is noted there also. That is noted there. Now, she is having more marks. It's a direct recruitment post.
But my lord, considering her past service.
That you should have come up here before the selection. Now, after the selection, we can't ask them, give marks.
But what to have call for interview, my lord? That there is a
Next round of selection.
only there is a difference of.
Some other man. You are paying for? You are Medhi, you are.
But the But the remark of the section committee,
The selected.
You have not filed an affidavit here.
but the remark experience is experience in 3 months. But here the Minalini data you have written as only widow, my lord. The experience is not counted.
Give it. Give me the disposal. Dismissed. Next time, better case.
But according to the advertisement, she ought to have.
I don't find. I find that the selection process is also in tune with the
But-
prescriptions, with the statements you have made in the request. If you tell me that the marks therein recorded, noted are wrong, I would be with you.
Only 2 months, but her past service maybe.
Every year we talk about it. Better case. Let them. She is working from such a long time. Let her work.
Did you have nice lunch?
Mr. Chaudhary, Mr. Majumdar, why are you all waiting for?
Next one.
Okay.
There is this case, but a staff selection committee, organized, hold a selection procedure for appointment.
Affidavit filed. Mr. Gogoi, you are not filing an affidavit?
No, I have not received instruction. Lord.
On the prayer of Mr. K. Gogoi.
May I pray, madam? I have talked with Mr. Gogoi also. Whether his candidate, sir, he was candidate of EWS. Annexer 67 page 8, madam. This certificate, was issued for the post under government of Assam. And the post advertised was under the central government. Only for that, his candidate, sir, was.
Rejection was done, Lordship, on the basis of the EWS certificate, Lordship, which has.
No,
annexed in
EWS, is there 3, 4, 5 certificates, formats, autonomous? EWS is EWS. And who has issued that certificate? Deputy Commissioner.
Circle officer.
Circle officer. Then?
Page 67, my lord, mechanical page. For seat in education institutions and post under the government of Assam, Lordship.
That is how can an officer, circle officer issue a certificate
Now,
for the central government?
Now,
You show me the requisite format you have.
No,
you show me the requisite format you have.
Lordship.
The format that you require, where is that?
Now my Now my friend Lordship bring another certificate, Lordship. That indicates that it should be also central government.
At a time, one certificate issued. When he came to know this certificate is not considering, then he again approached and deposited the earlier one. Then,
Given the nature of dispute raised in the present proceeding, it is directed that the respondent authority shall invariably file their affidavit in the matter as a last chance on the next date of listing. Failure to file the affidavit would mandate directions for appearance in person upon the competent authority. Raised to list this matter again after 2 weeks on a date.
Lordship,
fixed by-
it is 4 weeks, Lordship.
4 weeks on a date. Because this is
Otherwise,
required to be.
Lordship, we both are discussed, Lordship may even remand back the.
No. It will not help it. But why should a poor boy come back again?
Yes, because he has.
He is an unemployed boy. We'll settle it. We'll dismiss it or we'll allow it. Thirty?
Lord, a very short point involved.
Yes, sir.
Lord will kindly take the writ petition.
Oh, both the stalwarts are here today.
Oh, sorry, my lord. Oh, this matter, my lord, I think will take some time. I thought there was another matter.
Okay.
Here it's a case of compulsory retirement, my lord. Hello, now I remember. Now, in this case, the state has not filed the affidavit. I think they are proposing to produce the record. Am I correct?
Record, we can produce, but then today possibly records are
He
not.
is an employee of the office of the senior government advocate.
Our.
Yes, yes.
Oh,
There was some irregularity in, I mean, producing the case.
Just a moment, Mr. Chaudhary, just a moment. I was consulted here.
I was thinking.
I was consulted by the authorities. I think this incident happened when Mr. Nath was,
Yes.
then Mr.
He was the inquiry.
He was the inquiry.
Ranjit.
List this matter before any other bench without me. I'm sorry.
Well, let it come in the week after
No,
next.
I'll not make
My-
anything.
my-
38, 39.
Yes.
Kindly find order dated 8/5/2024. There was a direction to the respondent to invariably file the affidavit.
Yes, Lordship, inadvertent mistake, Lordship.
So that inadvertent mistake, how long will you take to rectify?
1 week, 1 week.
1 week. List this matter on the assurance of Ms. M. Pachaji, learned additional senior government advocate appearing for the respondent, that the affidavit would be filed on or before 9/8/2024, 9/8/2024.
I'll be.
List this matter again on 13/8/2024.
In both the written.
Both.
Yes,
2000.
Deeply obliged.
All right.
It orders me. Admission is to be accepted. Yes, Mr. Sama. Aha.
So can you see last order dated 26/4/24? The government was
Just tell me the
directed
date of death of your father or mother, whoever it is.
June 2000 also.
Huh?
26/2000 Lordship.
2000.
I think also there is some communication by the government.
2004 I have dismissed today, just a little bit. Heard Mr. Arshama, it looked up. Any other respondents here? Your cases, you have come before this court earlier?
Yes, okay.
When?
In the year 2014,
What was the direction? Consider.
to consider, within 1 month,
And then what happened?
there was no communication from the government.
After 2014, you have not come up before this court.
No.
You have filed this writ petition. This is in 2023. Dismissed.
Deeply obliged.
Sorry, Mr. Sharma.
43.
Yes, Mr.
Well, this is the case actually I was referring. Lord will kindly mark the date 18/3/23, page 13. The petitioner was suspended.
18/3/23.
Yes.
Suspended.
The
Any
order is at-
departmental
Order
proceeding?
is at page 13.
It's 6/1 or 6/2?
6/1, my lord.
6/1.
Yes. No police case. Yes. Then, my lord, on 24/6/23, show cause notice was issued, which is at page 14.
24
24/6/23.
show cause.
Now, admittedly, review was done, but on 12/7/23.
Para 21, Ajay Chaudhary.
Yes. Now, my
Who is appearing?
simple case is, my lord, even if it's a case where within 90 days, neither review was done, nor my lord.
So you are
show cause was
referring to
issued.
page 40 of the affidavit,
Yes,
wherein they have brought that on record.
yes.
The-
My lord, my humble submission is very simple. Now, it is something like a legal fiction. Here, there is no scope of,
No.
any my lord, free play is available. My lord, it's a principle which is borrowed from section 167(2).
Of this CRPC. And Mr. Chaudhary, subject to what Mr. Naik says, the para 21, the opening three lines, it says 90 days, or if you issue an memorandum,
Yes.
along with that, you will have to pass an order with regard to the suspension.
Review. Even if you show cause notice also.
Same
issued.
day.
Yes.
Para 21, 3 lines.
Yes.
Yes, you are, yes. I'm waiting to hear you.
A so-called.
We'll ask Mr. Chaudhary that he is wrong. We'll tell him, but you satisfy me.
Within a period of 3 months.
You get Ajay Chaudhary. we have been following a principle that within 90 days, if it is not done, we can extend it. I feel that is wrong. It is within 90 days. If you don't do it, it's gone. But if you issue a show cause within that period, then a consequential order has to be passed. Subject to correction, Mr. Chaudhary, you also.
That's the law.
Yes, that is it.
Then you have issued a show cause on 24/6/2023.
3 days delay.
I'm not on that. I condone that delay.
Yes.
I condone that delay. But on that day, you were also required
No,
to pass
not
up.
on that day.
You see,
That is part one, part
You-
two I
you
was
see,
pointing out.
you see.
21. We therefore direct that the currency of a suspension order should not extend beyond 3 months if within this period, the memorandum of charges sheet is not served on the delinquent officer employee. That is one part.
Right.
Second part, if the memorandum of charges sheet is served, a rejoin order must be passed for the extension of the suspension.
So all these things
For
will
the
go
second-
together.
For the second part, there is no such
No,
time period.
that I'll provide.
But in this case, Lordship, we have already extended.
You have done it on 12/7, beyond the date.
That is what my
You tell me
submission.
what is the date,
No, so
what is
far
the
as-
time frame? Say,
So,
a show cause is issued. It is like a charge sheet being filed.
yes.
Now you will have to decide whether this man's detention is required or not.
No, but for example, the issue is if charge sheet is not filed, one is entitled to default.
Default bill.
Now, what is the test? Test is not one day thereafter.
No, on that day.
That day.
No. That is the
That,
inter.
that
For the
Mr.
second
Naik,
part, for the first
Naik,
part,
Mr. Naik, I'll learn it. I'll rectify myself once you bring an order on this connection from the division bench.
Lordship, let me place just one paragraph of a judgment passed by our High Court.
I'll only follow Ajay Chaudhary, those
Paragraph-
three lines.
yes,
I
that
have
is-
understood it in that
Order
manner.
should be.
I can't help it.
Paragraph 100, Lord. Paragraph 100, Lordship. Now, where from that paragraph 100, Lordship? Lordship, kindly see.
This is an interpretation of this court,
Lordship,
which
from where?
I
From where?
respectfully do not agree.
From Ajay Chaudhary itself.
I do not agree.
Paragraph 18, Lordship.
See, when the main Bible is there,
Bible is
why
here.
should I go
I'm
for
reading
a-
the Bible itself.
or the Ramayana is there, why should I go for an
Paragraph
interpretation?
18 of Ajay Chaudhary. Paragraph 18 of Ajay Chaudhary.
Okay,
Paragraph
anything
18.
more?
Paragraph 18, Lordship.
Anything more?
Paragraph 18, Lordship will kindly see.
You
one
tell
minute.
me, tell
It
me,
will take
para
1
18.
minute, Lordship.
Para 18.
Paragraph 18, one sub-para is there, paragraph 5. It
Okay.
is a judgment quoted from the judgment of Abdul Rahman Antule versus R.S. Nayak. This is a constitution bench judgment, Lordship. Paragraph 18 of Ajay Chaudhary. Then
It's reported, it's reflected
Yes.
here.
Then paragraph 86 of that judgment, sub-para 5, Lordship, in the next page.
86.
While determining whether undue delay resulting in violation of right to speedy trial, one must have regard.
Okay, we'll consider your thought.
This is the statement. This is same, Lordship, 100 paragraph 100 of that.
Anything more, Mr. Chaudhary? Anything more? Para 18, we'll consider your judgment. Anything more?
At least I have obtained 3-4 judgment where even after elapse of that period of 90 days, Lordship, I have been given the opportunity of reviewing the
Here,
suspension.
Mr. Nayak, it's not the question of lapse of 90 days default bill. It's the question of filing of charge sheet. What is to be done?
Lordship, here, Lordship, suspension was on 18/3.
Huh.
And the
That
subsequent
period
issues
goes
on
on
24/6.
17/3/23, your period goes. We can hold it by your own statement in the,
Affidavit.
no, in the affidavit and also what you have submitted. That 90 days, that will go. You have read the Ajay Chaudhary in that line.
Yes, that is.
So
that
this
is
can
the-
this can go on that count. But we are giving you the long loop. Okay, you issued a show cause, very good. At least there was some delay, administrative delay. 24/6. My case is on 24/6, you must have issued an order, not on 25th, on 24th itself.
Then
Along
Lordship-
with that.
Lordship will kindly record my submission. So far as Ajay Chaudhary is concerned, paragraph 21, there is no time frame for issuing a.
You do one thing, I'm passing the order tomorrow morning. You give me whatever you want me to record, you just give it to me in writing. But we are interfering in this. I'll consider you.
The 2-3 judgment, let me let Lord.
You just give me a list. Mr. Chaudhary, wait for a day. I'll pass the order on Friday. Let Mr. Nayak has the full satisfaction of placing it tomorrow.
My lord, also kindly delay that point of my lord legal fiction. I think that will make the position more clear.
Because now the situation after those 3 lines is clear. I was sitting in Arunachal. I passed a similar order there. It's not that for the first time I have developed this. I've already passed an order.
No, my lord, what I was trying to emphasize is, if this 90 days period is not, kept in mind, then the whole purport of Ajay Chaudhary will be lost.
Para 21 is lost.
Lordship, then why only Ajay Chaudhary, Lordship? Let me place another judgment then, Lordship. Ajay Chaudhary is not the only judgment.
We are learning, Mr. Nayak.
2013,
Teach us.
2013,
2013,
16 SCC, 147.
147, yes.
Paragraph 22, 26,
What does it
27.
say? What does it say?
There, Lordship, one line, Lordship. Effect of public interest due to the employee's continuation in office, suspension is the issue, is also a relevant and determining
Nayak,
factor.
Reserve your
One
energy.
line, one
You will
line.
have more matters. Reserve your energy. These submissions will not come in because in Ajay Chaudhary, the Supreme Court has itself said that till date, we have not put a time frame on suspension. It is for the first time we are putting it paragraph 21 towards the end.
And also that earlier reluctance of the Honorable Supreme Court to interfere in the matter.
But you, Mr. Naik, I'm with you.
Lordship
We will
Lordship
dismiss Mr. Chaudhary's
Lordship
petition, no problem. Tentative view I have taken. I'm not taken a confirm view. You give me whatever you have in writing tomorrow. I'll have the matter on Friday. We'll pass orders on Friday.
Lordship.
Right? Mr. Chaudhary, you need not trouble. Let Mr. Younger Chaudhary be there. Had the parties at link. List this matter again on Friday for delivery of orders. But I want it tomorrow.
By the evening loss.
Huh?
By the evening loss.
Whatever. I'll only read in the night. I can't read in the daytime. You give it to me before I rise tomorrow. Okay. Next.
4 to 46.
Yes, Mr. Vora.
Lordship, we have released him, Lordship.
This particular case, Lordship. is a
For
perfect
release only.
Example of.
Anything where? Anything more?
This is a perfect example of making me a victim to that extent, even though overreaching the judgment of the Honorable Court.
Now that you have been released, is there anything left?
Your Lordship, they have only issued a provisional joining because of the pendency of this case.
We will close it and ask them to issue a permanent one within a week. Yes, what is it?
We have released him, Lordship. The release order.
What is this observation? He will observe anti-malaria precautions.
Lordship, they have not
This is usual, Lordship. This is a prototype, Lordship. You should.
What is the tenure there? Your tenure in ICR?
Actually, it's a permanent.
He's gone for permanent.
Permanently.
Transfer on absorption basis. What they are doing, what they were doing all this while, on one hand, they have filed IA seeking time from the Honorable Court saying that they are going to comply. At the same time, behind the back.
Have you gone and joined there?
Yes.
Nothing
But
said.
this is
Nothing said.
Lordship,
What he wants
just
now,
let me
Lordship.
complete. Let me complete.
He may have something to say. Let him. Yes.
If your lordship may kindly go to the last line, RLC East for info.
Now, the inquiry gone.
Lordship,
What will you do with the inquiry?
that will depend, Lordship.
No. Tell me. We'll have to.
Lordship, that
No, he's no longer your employee.
Lordship,
How can you continue?
whether initiated prior to his leaving, Lordship.
Be that as it may,
Lordship, whether that will be go or not.
that will go.
That
What
part-
is the charge? Tell me.
Lordship, that part may be the Lordship may fix some other date, Lordship. Let the contempt.
Where is the
let
show
the
cause,
contempt,
Mr.?
both the contempt be closed, Lordship.
Where is the show cause?
So call is at page number 68. Charges are at page number 70.
Page number?
68. It starts at page number 68. And the statement of imputation is at page number 71.
Oh, what is that?
Lordship, something needs to be decided, Lordship.
No,
No,
this
Lordship-
is not maintainable after you have relieved him.
Lordship-
All pertaining to the manner he
Wait,
which-
Lordship- Lordship
and that
may
is
be-
already covered by the decision of this court.
Yes. Page number
Lordship,
65.
Lordship may fix
Paragraph
another
15.
date, Lordship, for that. Let the contempt be closed, Lordship. For the writ petition, Lordship, fix
No,
another date.
we'll do it together. But I want this to be also withdrawn because this cannot be.
Lordship, fix.
These are not misconduct once you have released.
Next Tuesday, Lordship.
Friday. You have your instructions. Can you? Mr. There are contempt petitions also.
Two
Yes, Your
contempt
Lordship.
petitions.
After the stay order was granted by the
We'll
Honorable
close the contempt petitions.
They continued with the dismissal. That's why I filed it.
Mr. Bora, you appear decide also. What you are putting here, we'll put it there also. So be reasonable.
Very good.
Huh? Once you are also a government, you know what the other word is. So don't become a government master. Remain. Contempt case number 730, 2023 and contempt case 48, 2024. The learned counsel for the parties have submitted that the directions passed by this court, the same case in both the matters.
The earlier contempt of 2023
Huh.
is with regards to the 5323 of 2023.
Passed by this court in WPC number 5323 of 2022 and in WPC number second one.
Contempt 48 of 24 is in WPC number 6886.
6886/2023 has since been complied with, and the petitioner, on being released by the respondents, have already joined the post he was selected in Indian Council of Agriculture Research, Patna. So, in view of the above position, the directions passed by this court having been complied with, no further and there being no allegation, no further allegation, and the order having been complied with, this court is of the considered view that the further detention of this present contempt petitions for adjudication is not called for, and accordingly, the same stands closed. The order dated, release order dated 11/5/2024 as produced by Mr. B. Chakraborty, learned CGC, is kept on record and marked as X.
Respondent number 2 in the contempt will be.
In response in the contempt. I just contempt 48.
Also, Mr. D. Bora, learned counsel for the petitioner, Mr. B. Chakraborty, learned counsel for the CGC appearing for respond number 1, and Mr. S.K. Medi, CGC appearing for the respond number 2 are present.
Obligatory.
And now the main case. We'll have it on Friday. Only one writ petition.
Lordship, can it be Tuesday or Thursday, Lordship?
Heard the learned counsel for the parties as agreed to by the learned counsels. No, full stop. Parties, full stop. The primary relief as sought for in the present writ petition has already been granted by the respondents. Oh no, here it is a challenge to the memorandum of charge.
Yes.
Okay. Mr. B. Chakraborty, Learned Counsel, Learned CGC, appearing for the respondents, has submitted that the petitioner was released from the organization and he has already joined
Provisionally.
joined the Indian Council of Agriculture Research, Patna. Released from the organization provisionally and joined so and so. However, no decision. However, it is contended by him that no decision has been arrived at in the as regards the manner in which the departmental promotions, so departmental proceedings so initiated against the petitioner would now be processed. So accordingly, he prays that he be granted 10 days time to receive instructions in this matter. So accordingly, raised to release this matter again on 22/8/2024.
Okay.
What is this IA for?
Interim order.
We have filed an IA for vacation of the stay order. Let it be kept off.
Why? Why?
Let it be kept off.
No.
The further proceeding was stayed, Lordship, in the departmental proceeding.
Actually, rightly so. If you want, I'll give a reason for this. That will also have.
Lordship, that will be, let be decided on that day also.
I want a small cause list. Writing this, it becomes very big. Okay.
Interim
I had to
order.
take a look. Interim order passed earlier to continue until further orders.
Highly obliged.
A contempt to dispose.
47.
Although he has joined as voluntarily under Modurban Napara Angoni Center in 2009, but after 2016, as per our report, Lordship, he has started working at number 80, Modurban AWC, for which he was asked to go back. So he is working in some other place, Lordship. And as per the report, Lordship.
Yes. Mr. Purkaiso.
This is not correct, but actually,
Hmm.
but I take your lordship to the page number 34.
Show me what is it. Any order?
Yes,
Asking
order
you.
of this honorable court is there, my page 33, my lord. The direction to release my pay, my lord, where, irrespective of where I am serving, my lord. Page 33 is the last part, my lord. And they are not, my lord, showing the place of work, my lord. But as per, the lordship will find the report of the supervisor, ground field level.
In fact, the last pair out of
Where are you working now?
And as per field level officer, I am working in the, my lord, 261 number, Anganwadi number.
The last pair out of pairs.
Let me.
261 Modurban Natpara Anganwadi Center.
Yes.
Okay.
It is, my lord, you will find at page number 34, it's given clearly.
And you say
35 is
that she is not there? Huh?
The number is center number 80, Lordship.
It's
The
here.
last pair out. That is the annexer. The last pair out of pairs.
Okay, proceed against her, issue a notice and terminate her if she is not working within in terms of your order of appointment, right? She is just a casual worker, so 64 rules will not come in. Issue a notice to her, bring her this to notice and take appropriate steps. And if she is found to be working in that 261,
Yes.
she will be released her salaries.
Yes. As per report of
The report is already there.
supervisor.
Under report, it says she is not in fact attended.
Okay, done. Anything more, Mr.
No, matter of my lord, remanded to district social welfare, my lord,
No,
officer.
I'll direct the director here to
Oh,
take the
yes,
process.
director. Director or the district social welfare.
Board is in matter asking board as to asking Kumar material. Because of material. Wait for 10 minutes. Just have a change. Finish any idea.
Item 48 and 48 to 51 and item 5.
Back to the
Please, your lordship.
No, wait 1 minute. We'll take up 5 first.
My lord,
The facts of the Panchayat employees, my lord. Panchayat employees are initially appointed in 1957 and onwards with a fixed pay temporarily. my
Where
lord.
is that act? Kali boot matter asani.
I have given a picture copy.
If I was in. Kali no itu. এইকেইটাটো মোৰ তাত আছে এইকেইটা কালি কৰিব লাগিব না 7টা অৰ্ডাৰ দিব লাগিব কালি এইকেইটা পাৰ্ট নেকি এইটো এই সিৰিজটো 15টা যাব 15টা ওলাই দিলে কিমান হ'ল 45 এইকেইটাটো সিৰিজ এইকেইটাৰ কাম নাই বেছি বেছি নাই Yes, sir.
Lord, kindly see the preamble of this act, my lord.
Appointed day means the day on which this act came into force. Date of appointment means when he charged. Now, the pension is provided for under. There is a so not insurance of Now you come to the judgment of my lord Justice Roy.
Page number 38, my lord.
Of
Sorry
for Nessa.
My lord, division bench judgment, my lord.
No, it's in that 48. I don't know 48. Right?
38, my lord. Fazler update.
No. Item number, how much?
Item number 48, my lord.
48. Page?
Page, my lord, 38.
Okay.
Page 46, my lord, 45. Date of appointment and date of retirement mentioned, my lord, of my lord petitioner vice lord. Here, Fazler Rafi appointed in 1957 and retired in 1993, my lord. Page 45.
Page 64.
Hello.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines from bottom. The key. That was what I was asking for. Mr. Counsel, Mr. Handick, have you gone through this judgment?
My lord, I have.
So, herein the division bench has said, for the purpose of entitlement of pension and all, after a person is provincialized, his date of appointment would be taken into note. Date of appointment in the Panchayati Raj institution, not provincialization. So, if that date is taken, everyone has more than 20 years.
My lord, now the instructions that I have, my lord, I'll just share with my lord.
And when there is a decision on the point of this court, which was again upheld by the Supreme Court.
Not upheld. It was just dismissed in limine.
That's it,
Didn't go
upheld.
into the merits.
All right. That is upheld. What more? This judgment has not been interfered with.
Not been interfered.
Huh.
Now, matlab the
And
class-
there is, it's not SLP dismissed. There is a further line there. Some implementation was directed. If I suppose the SLP order,
Yes, Your Lordship.
you have the SLP order?
Yes, Your Lordship.
Just see read the order.
Well, page 67.
67,
It
yes.
just says the special leave petitions are dismissed. That's
Just
it.
a moment, just a moment. No, there was one more. Was a review filed here?
No, well.
Yes. What are your instructions?
Alright, nice. At page 15, Malad,
Of this instructions?
instructions. Malad.
Is it numbered?
Yes, Malad, I've just numbered it.
Yes, what do you want to say?
At page 15, what had happened is that on 16th of November 1991,
Page 15 of which page? Which case?
Malad, the instructions that I've just shared with my lord.
Yeah, there is
From
no
the department.
pagination. This one?
This one. Oh, you can-
It's a letter dated 12/7/2024.
At page 15. I can hold it. Look, this is the provincialization order dated 60/21. So till 1991, Millet, they were not working against any sanction posts. Subsequently, at page 16, Millet, posts were created. They were regularized against sanction posts and accommodated against those sanction posts in the year 1993. The order is at page 16, Millet. With effect from 1991. So their date of entry, Millet, as for this judgment also, which I've shared with you, the services that have been rendered prior to their regularization.
Is that
will not-
on the Panchayati Raj Provincialization Act, that judgment you have referred to me?
Millet?
The judgment that you have referred, is it also on the same act?
Millet, it's not the
Interpretation of
same
the-
act. It's based on Doordarshan. What had happened is that in 85,
We have a interpretation by this court division bench on the provisions of date of appointment and the date of appointed day. Appointed day is 91. Date of appointment is the date when the person entered the PRI institution. PRI is the Panchayati Raj institutions as it stood before provincialization. Now this court said for that period, the pension and other pensionary benefits, everything, service benefits, would be on the date of appointment, not the appointed day.
Millet, but PRIs as such won't be paying the pension. It's the government that will be paying the pension.
I'm
and
sorry, you're
pensionary
too late
benefits.
in the day. You're too late in the day. Mr. Handick, you should have been there when these matters were being argued. There were contempt petitions. Why I'm telling you, because I had an occasion to appear for the respondents again. So today, this argument will not hold field. Right?
Millet, because if one peruses the judgment, it says that the
I think
services-
it has been taken back again. Just give me the citation of the judgment.
Millet, it's 2023 Live Law SC 248.
240.
248.
And what is the name of the parties?
Director General Doordarshan Prasar Bharati Corporation versus Srimati Maggi H. Desai. MAGI.
MAGI.
Desai.
Maggi
Desai.
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 DESAI. Okay.
Same Millet, casual employees like the petitioners herein. They were appointed in 85,
I can't.
regularized in 90.
I can't because I'm bound by this order. Because this is an interpretation of the
Pension rules.
pension. No, of the Provincialization Act.
Millet, but this judgment overrides the principles that were laid down in the division bench.
Will not be. It's an interpretation. It says date of appointment is the date of initial entry.
If my lord just reads the definition of employees in the Provincialization Act.
You see the date of appointment. Read the date of appointment.
Well, a date of appointment says means in relation to any employee, the date on which he joined the services of the panchayat. But after that, there's a definition of employees as well.
Okay, fine. Show me.
Date of appointment, as my lord says, it's the, in relation to an employee, the date on which he joined the services of the panchayats. D, employees, means a person in the employment of panchayats against a regularly sanctioned post. He was accommodated against a regularly sanctioned post, White Order 1993, my lord, with effect from 91. And then Section 3 of the Provincialization Act says, provincialization of the employees of panchayat under state government, subject to the provisions of Article 30 of Constitution of India, all employees of the panchayats under the
Mr.
state
Andik, that is also taken care of in the division bench judgment.
My lord, this stand of the state government has been vindicated by this judgment of the Supreme Court.
I can't
because
do it.
That stand was not.
That is
accepted
a
back then.
prospective law that came today, but their rights have crystallized then. We
But
can't
there are
change
many
it.
fence sitters who have approached this court for the first time. All those who have been.
We are rejecting the submission.
But actually what happened, all those people who were parties in the original.
You can argue for the day. I'll sit here and hear you for the 2 days, but it's not going to move me.
Just one submission.
Hmm.
What my learned friend is saying,
Hmm.
I'll just supplement to that. That one is overruling of judgment, overruling of principle. In this case, my friend is submitting.
You
that the
make those submissions,
Princ-
reserve it.
Principle has been overruled.
You make those submissions before the division bench because the order is of the division bench. Get it corrected. Further petitions that come to me, I'll follow that. But today I am
That
following this.
Judgment passed in case.
Yes,
of-
what is your grievance, father?
My lord, my.
Mr. Naik, that argument I'm not buying.
Lordship, that judgment,
My
who are the
grievance is-
petitioners, in their case, it will be
No,
complied.
it is a law in rem and that has also been held by this court.
Even after the overruling. of
Yes,
the
this
principle
judgment
is-
is a judgment in rem held by this court in spite of serious objections
Lordship,
from
our-
this side as a
our-
standing council, pension and family.
Our submission is that pension was given to them by relaxing under Rule 31 of the pension law. Now the law is.
You have
Super-
relaxed Rule 31 in
Yes.
this case. Where? Where is the material? Where is the material? Show me. Yes, what is your grievance here?
I
What
mean,
a
the
grievance.
earlier
This is my
part was
point of
taken
view,
care of by relaxing under Rule 31.
My grievance is that my length of service has been deducted, my lord. My lord, kindly see my lord.
So you are saying your case is that the date of appointment in your case was not considered
Not considered.
and
From
the
the
date
date
of
of-
provincialization was considered for your payments.
My lord,
That's it.
my lord,
Nothing more.
nothing.
So,
My
and
lord,
the judgment of my lord Justice Bujurburwa
my lord,
will cover your case.
my lord.
Okay.
My lord,
Anything more?
This judgment passed, my lord, these petitioners, my lord, in favor
Hmm.
of these petitioners. Sorry, Gurnesa and the Mr. Justice Buzurba's judgment is the same man, same person.
Oh, same person.
Same
But
person.
you have filed this because you have not been given the full benefit.
Confirm, my lord.
Done. Heard the parties at length. Where is that 31 relaxation?
What order is there, like, file page?
And Mr. Naik, after the decisions in the earlier round of litigation in their favor, the Panchayat and Rural Development Department, naturally with your concurrence will have to do it, pension also. They have said that we are implementing the decision.
Yes, Lordship.
Page 93 is in your respect. Azizur Rahman,
Yes, your lordship.
your,
No,
Your-
Ajit Rahman, well, I'm relying on the judgment. my
okay,
lord.
you are relying.
And in the judgment, my lord, the total length of service was considered.
No.
That period only, whether the entire first period should be counted for pension or not. If it is counted, then they will get the full pension. If not, then Lordship, it will be limited to proportionate pension. They will get pension, but whether it will be full pension or proportionate pension.
And Ajit Rahman judgment has already, my lord, complied. with.
Complaint. So anything more? Anything more, Mr. Handick?
Well, I have the office memorandum, which talks about the relaxation of Rule 31.
In respect of the Panchayati Raj
Yes,
employees.
yes. At page 24 of the pension.
What is the date of that?
3rd of July 2013.
3rd of July 2013.
Page 24 of the book.
Just give me that. It will be. Mr. Handick, just give it to me.
Well, at page 20.
Mhm. Yes. Read it again. Read the last two lines again. Governor is pleased to do last three lines.
Rendering less than 10 years of service are not eligible for pension.
Read.
Further, the government employees rendering less than 10 years of service are not eligible for pension. Therefore, such government employees are eligible for service gratuity under Rule 108A of Assam Services Pension Rules 1969.
No. There is a thing that relaxation of 31. Where are you reading?
Well, at office memorandum dated.
Read the whole office memorandum.
The governor of Assam is pleased to sanction the payment of pension to the provincialized panchayat employees by relaxation of provision made under Rule 31 of the Rules 1969 for enabling entitlement of pension whose services have been provincialized under the Assam Panchayat Employees Provincialization Act 1999 and who had retired from service on or after 1991 after serving more than 10 years and less than 20 years from the date of their initial appointment as special case not to be treated as precedent.
From the date of their
initial appointment?
That is?
Against sanction post also.
No. It does not say so. It says initial appointment read with the decision. Date of appointment is the date when they entered into the, because they could not have done it because that would have been violation of.
But it further says employees. So employees is when you are.
Have you filed an affidavit here?
If not,
then you don't make submissions. Wait.
Let me file an affidavit.
I'm sorry, you did not make a prayer. We are disposing it off. We are allowing the prayer. And next time, if you have not brought a foundation on record, please don't make all this submission. Pray for a liberty to file an affidavit. Will not hear you. Heard the Learned Council 5, 48, 49, 50, 51. Heard the Learned Council for the petitioners. Also heard Mr. P. Handick, Learned Standing Council, PNRD Department, and Mr. P. Nayak, Learned Standing Council, Finance Department. Registry to, full stop. Hearing concluded, registry to list this matters again on 22/8/2024 for delivery of orders.
But I may be allowed to file my affidavit.
You will not be. No further pleadings is permitted to be brought on record. There is a certain procedure in doing cases before this court, right?
Well, if the entire.
First, Mr. Handick, you are a very bright lawyer, enthusiastic person, but also keep the manner in which you do cases in mind, right? I like you. The way you emphatically say things, I like it. But me liking will not do. There is a procedure in this court. Follow that also. Okay, next. Yes, Mr. Das. Mr. Dasgura, why are you waiting for? Huh?
Can wait till 5 p.m. no problem.
No, you can wait, but it feels bad for me. You, Mr. Dasgupta, all sitting. It doesn't feel good. I don't like it.
Because he's younger than me.
And he's Devanand. Yes, what is your issue?
One, item number 39. On contempt matter, they are supposed to produce their compliance order.
Item number?
39.
Yes,
59 or 59.
59. Yes, Mr. Gugoi. Where is the compliance order?
Yes, my lord, the all along, my lord, it was registered by the finance department, the issues of regulation. Now finance has concurred, my lords. See the,
Last order, your lordship.
so my lord, the
Order will be passed by tomorrow.
there is one order, my lord, and I hope, my lord, can be listed next week, my lord. I have to take instructions as to the chief engineer has recommended he forwarded his file to the department. All along, my lord, we didn't willfully or deliberately, my lord, didn't commit any contempt, my lords, or alleged contempt, my lord. It was registered by the finance department all along. Now only they have concurred, my lords.
Page 22, 524.
Announce party or scenery.
You give a copy of this to
Yes.
Mr. Das. I think Mr. Das, it has been complied with.
Complied.
They have said you are regular to forward your pension papers to the AG for pension.
They also entitled to get the arrear amount.
Yes, whatever it is, just see. Heard Mr. B.D. Das, Learned Counsel for the petitioner, also heard Mr. D. Gogoi, Learned Counsel, Standing Counsel, appearing for the
One,
respondent,
One,
Learned
two, and
Counsel for
eight, my
the,
lords.
appearing for the respondents number 1, 2, and 8. Mr. Gogoi, by placing on record, odd communication dated, what is the date of the communication?
4/7.
4/7/2024 has submitted that the Finance Department has granted its concurrence to the regularization of the services of the petitioner, and accordingly, the follow-up steps as requisite in the matter is being so taken by the departmental authorities, and the same would be concluded within a period of 2 weeks from today. Accordingly, registry is directed to list this matter immediately on conclusion of 2 weeks. On the next date of listing, Mr. Gogoi shall place before this court the full compliance report. The compliance report shall place before the court a compliance report wherein the directions passed by this court by the order dated
That's an order.
by which the
19/7.
directions passed by this court by order dated 19/7/2023 in WPC number 1231/2022 has been fully complied with. Let us wait for a date more, Mr. Das.
Date may be given.
2 weeks, I said, on immediate and completion, you want a date? Okay.
Date would be
Aji ki
complied.
mandri.
Date will be proper. Giving a date will be helpful.
19/8/20.
19.
Complied.
Always.
Yes, Mr. Dasgupta, you have any pending matter? 50?
54.
They are now. Yes. Complied.
Lordship complied. There was some delay which we have explained by way of filing affidavit in opposition.
What is the direction?
Lordship, basically, as per-
Brief submission will conclude the case.
It's against that order dated 9 interlocutory order.
No, what happened in this case, very quickly,
Hmm,
an award was passed in my favor. that award of reinstatement. They approved before this court. And this honorable court granted stay order. And then again, I approved before this court for payment of last wage drawn as contained in
17.
section 17B. And that was granted. And they started paying payment. Now, the dispute is here for the last wage drawn. According to us, you have not fully paid to us. Now, in the meantime, what happened? I attained the age of superannuation. So, till the day attainment of age of superannuation, I am entitled to have the last wage, not beyond that. Now, so I approached the labor court for its due computation. The labor court said me, no, when you have approached the high court, so get it closed and approach to us. So far, this amount is concerned, it can be computed by them. So, in view of this position, I would like to close this petition so that the labor court can compute this amount. Let the matter be there for tomorrow.
Okay.
Friday. It will be on merit also, your lordship computes.
Because if they have implemented whatever they have done, if they have done it, we will say that we'll say that this is done. But as far as the actual computation, because you have a dispute, you are at liberty to approach the appropriate forum for computing. Approach. And the appropriate forum will consider.
The only thing is that it should be continued. The labor court proceeding should be continued. Labor court proceeding.
We can close it. We can ask the labor court to do that. If you want a date, we'll give it on Friday. We'll have it on Friday. Friday. It would very bad. By slip
on the merit also, on the main case also, that should be taken. But very.
Contempt is there. We'll close the contempt, then come back to. Oh dear.
Review list.
Heard Mr. A.B. Pukhaisto, learned counsel for the petitioner. Also heard Mr. C. Sharma, learned. No, not yours. This is different. Mr. Sharma, you are appearing for the item number 40. No, Mr. C.K.S. Burua was appearing. C.K.S. Burua, yes. That Natpara. C.K.S. Burua, learned counsel, learned government advocate, appearing for the state respondents. The grievance raised by the petitioner in the present proceedings is with regard to the non-release of our salaries with effect from salaries for the services discharged by her as an Anganwadi worker at number 261 Modurbon, Natpara, Anganwadi Center. You, Mr. Purkhaisa, you are saying that you are still working there from okay. Now, worker, in terms of the
original appointment.
In terms of her engagement in this connection. The petitioner further praised that she be also permitted to continue to discharge her duties at the said Anganwadi Center in terms of the directions passed by this court, while ordered it at 17/1/2023 in WPC number 7299/2021. Also, right? This is your case?
Yes.
Also, as projected in the writ petition.
In support of that contention, my lord, I have annexed 7(1) ABC allotment.
Page,
my lord, 34.
Okay, we'll see.
Report of the supervisor.
As projected in the writ petition, the petitioner was engaged as an Anganwadi worker under Patharkandi ICDS project and posted to Modurbon, Natpara, AWC, Anganwadi Center, via a communication dated 23/12/2009. It is the contention of the petitioner hearing that she is continuing to discharge her duties in the said Anganwadi Center. However, when were your salaries stopped?
I'm giving the date.
However, salaries were stopped with effect from so and so date, the dash period. So, the petitioner her remuneration was stopped. So, the petitioner being aggrieved by the action on the part of the respondent authorities in not permitting her to continue her services in Madhurband LP School, Anganwadi, Madhurband Natpara Anganwadi Center and requiring her to discharge her such duties at Madhurband LP School, Anganwadi Center, the petitioner had approached this court by way of instituting WPC number 7299/2021. So this court white ordered it at 17/1/2023 on noticing the issues arising therein and on considering the rival submissions of the parties to the proceeding, proceeded to dispose of the said petition with a direction to the respondent authorities to allow the petitioner to work as Anganwadi worker in center number 261 at Ward 6, namely Madhurband Natpara Anganwadi Center. So, it was also provided that if the petitioner is working at center number 80 in Ward number 5, she shall immediately cease to do so and start functioning in terms of her original appointment order. So, the respondent authorities were also directed to examine the claim of the petitioner of not having received her salary since the filing of the writ petition. Also, Mr. Purkai's thought by relying upon the contentions made in the writ petition and also the annexures thereto has submitted that the petitioner all along was discharging her services at a Natpara Anganwadi Center, and accordingly the respondent authorities ought not to have withheld her salaries for the services so rendered by her. So, where is your that instructions?
Perhaps it is with lordship.
Oh, yeah.
I have not collected.
So, Mr. C.K.S. Borua, Learned Counsel, appearing for the respondents on instructions have submitted that the fact that on instruction has submitted that the contention of the petitioner, that the petitioner hearing was required to discharge her duties at Madhurband LP School Anganwadi Center is clearly without any basis, in as much as no such directions were passed by the respondent authorities, and the petitioner on her own had proceeded to discharge her duties at Madhurband LP School Anganwadi Center instead of her earlier place of posting. So, it was further contended by Mr. C.K.S. Borua that the petitioner, although had initially joined at number 80 Madhurband, had joined at her initial place at the place of posting wherein she was so appointed. However, thereafter she started working at number 80 Madhurband AWC at Madhurband LP School at her own wing and at her own decision without the same being so directed by the departmental authorities. Also, it is submitted that the petitioner was directed to join her services at her initial place of posting, that is Madhurband Natpara AWC, and accordingly, in the said directions having been so issued, the petitioner had approached this court by way of filing a writ petition being WPC number 7299 of 2023. It is directed that it is further contended that the directions as passed by this court, while the order dated 17/1/2023 in the above noted petition requiring the petitioner to continue to discharge her services at Modurban Natpara Anganwadi Center has not been complied with by the petitioner herein. And accordingly, the petitioner not having been discharging her duties at the place of her posting, the salaries of the petitioner have been still withheld.
Since April 2022, my lord.
Withheld.
Withheld.
Has been withheld since April 2022. Also,
But
given the above position and the actual pace of posting of the petitioner hearing being disputed, the Director of Social Welfare Assam is directed to cause an inquiry into the matter after issuing due notices to the petitioner and after ascertaining as to whether the petitioner was continuing in her services at the original place of posting, that is Modurpur, GSA to likhi dibo, Modurban, Modurban Natpara Anganwadi Center, shall proceed to decide as to the entitlement of the petitioner for being paid her wages. So it is provided that in the event the petitioner is found to be not working as per the directions or with regard as per the directions of the departmental authorities, the Director of Social Welfare or an authority competent thereto shall be at liberty to take such action, disciplinary action, as may be called for against the petitioner in the matter. With the above, however, if it is found that the petitioner is discharging her duties in terms of her original order of appointment, the salaries of the petitioner as due to her and computed by the Director of Social Welfare Assam shall be released to the petitioner. The entire exercise as now required to be carried out in the matter in terms of the above direction shall be so initiated and concluded within a period of 3 months from the date, with a period of 2 months from the date of receipt of a certified copy of this order. Full stop. A copy of the instructions as received by Mr. C.K.S. Barua and placed before this court is kept on record and marked as X for the purpose of identification. With the above observations and directions, the petition stands disposed.
Master,
52.
The matter pertains to non-transmission of the service book by the department to the office of the AG. The Lordship may kindly go to the last order passed by your Lordship.
Yes.
Lordship, we have written a letter to the PWD to send the service book and the last page.
Yes, Mr. Naik, how long?
I have already communicated, Lordship, but I need some more time, Lordship. July.
Mr. B. Chakraborty, Learned Counsel, appearing for the AG, bracketed A&E Assam, has submitted that the said authority has taken up the matter with the PWD, with the authorities of the PWD for rectifying the last pay drawn of for reckoning the last pay drawn by the petitioner just prior to his, or by the last pay drawn by the petitioner on the date of his superannuation. So, Mr. P. Naik submits that both Mr. P. Naik as well as Mr. B. Chakraborty, Learned Counsel appearing for the respondent, submits that they be given further 10 days time to bring on record 2 weeks time. 2 weeks. Letter has already been given. 3 weeks time to bring on record the further processing as made in the matter in pursuance to the said letter dated 23/7/2024 as issued by the Office of the Accountant General, bracketed A&E Assam.
Praying for date to be fixed.
Immediately on conclusion of 3 weeks, come and make a mention. I'll fix it.
53.
Want some time?
4 weeks time may be given. In the meantime, I will file also.
Okay, disability pension. Mr. K. Gogoi, learned sages appearing for the respondent submits that he be given 4 weeks' time to bring on record the stand of the respondents by way of filing an affidavit. Prayer accepted. Release this matter again after 4 weeks on a date to be fixed by the registrar. Yes, you have got the
My lord, the order, my lord. They
so the promotions took place in 2006. That is before all these things. So that is under challenge. So how will you negate his rights?
my lord.
The promotion is not after the reference. The promotion is prior to the reference.
But after my lord, the dispute was raised.
Be that as it may.
But
Be that as it may. So he has a claim to that post of Rabba.
so my lord, now also the second question, my lord, the amalgamation, my lord, under Workman. That is also yes.
So this is gone.
My lord,
This is gone.
I will not say it's gone, my lord, because the
Yeah,
dispute
still-
raised by my lord all six, my lord.
95,
Yes, my
they
lord.
had placed it. 96,
2005,
2006, he got it.
And my lord, after raising the dispute, my lord, they
And now tell me, where was Rabha also holding a supernumerary post?
yes,
Sure.
all are same, my lord, on same footing. So, my lord, all 6 persons, my lord, came together and raised the dispute, my lord, through the union, my lord. But till my lord, the reference to the case was registered, my lord,
Okay.
it was my lord.
Today may not be possible. Anything more to add?
Normally, I have to make some, there is no wrong in the judgment, my lord. I am, your lordship fixed another day, my lord. I have to make a submission.
Heard the parties at length. Ms.
On
A.K.
a
Hussain,
hearing day, ma'am.
Learned Counsel, submissions of Mr. A.K. Hussain remains inconclusive. Accordingly, list this matter again on February 14/8/2024 for further hearing. I would not have apne ta quickly.
My lordship fiction, man.
14th.
Well, can it be 30-minute hearing?
14th. No problem. I'll reach it. Have that confidence.
Because
At 2 p.m.
because my lord, I have to. My lord, there is no wrong in the judgment, my lord, of the
I'm
tribunal.
giving you time. You take
Mal,
your
mal,
own
mal,
time whenever you want.
Mal.
Leave the date to my convenience. If you have any personal inconvenience on that day, tell me.
No.
Then forget. Mr. Goswami, we'll consider.
Your lordship.
Hmm.
So I filed my affidavit today, of lordship, on the ground that the enquiry officer submitted the enquiry report during pendency of the departmental proceeding, lordship. This enquiry report of the enquiry officer is not acceptable, and therefore another enquiry officer is appointed.
How can
shortly,
you?
lordship.
How can you? De novo inquiry? Where is the permissible? AK Dep 1971 Supreme Court, followed by our High Courts. Further inquiry permissible, re-inquiry not permissible. Where is your affidavit?
Filed in the 2nd of April.
You give me a copy.
Yes.
Yes, Mr. Nayak. Mr. Nayak has a take, so we'll ask him. Is it permissible?
No. Authority may disagree with the report of the
Huh?
inquiry officer, but
You can have a disagreement note. You can have a further inquiry, but you can't have a re-inquiry.
Only further inquiry, lordship, not re-inquiry.
Where is that order?
Order is not annexed here, lordship.
You have the order.
No, lordship.
Get the order.
First, may kindly fix on Friday, lordship, in this case.
Your lordship may kindly peruse the last order, my lord. After reading at the length, my lord, that order has been passed.
Not permissible. What happened to your criminal case? Criminal case.
That was not a final order, not been passed. My lord.
Trial.
Trial stage. I am agreeing.
Where is the inquiry report? Where is the inquiry report, Mr. Counsel?
That they have not annexed in their affidavit.
You don't have it also. Inquiry report is not with you.
Furnished, not furnished to us. They have also not annexed.
Miss M. Das, M. Kotogi, Learned. Standing Counsel, Health, what is it? Veterinary.
Husbandry and Veterinary Department.
Animal Husbandry and Veterinary Department shall place before this court the inquiry report as submitted by the inquiry officer already appointed in the matter, earlier appointed in the matter on the next date of listing. List this matter again on Friday. list this matter again on. Where is your show cause? Show cause notice?
Yes. Eighty to 83 page.
And why was an ICC not held? Why an inquiry? This is allegation against a lady.
Against two lady, Lord.
Huh?
Two
Why was an ICC not held? You hold an ICC. Yes.
Even now they can.
You can still hold it. Miss Big, M. Kotogi, I don't know about this. M. Kotogi, Learned Counsel for the petitioner submits that she be given 2 weeks time to take further instructions in the matter. So, list this matter again on 21/8/2024, on which date Ms. Kotogi shall complete her instructions and place the same before this court. Full stop. You take steps, I'm giving you time. Serious allegations.
There are two FIRs actually from the two.
Fine, fine. If you don't act in the manner it is required, how can we come to your aid? You act. Now you have 2 times. Discuss with Mr. Nayak. Do what is required. Come back to us. If we find that is supported by law, we will allow it.
May I pray for
Huh?
in my understanding, this petition is not maintainable because it's a silence of a suspension order under.
No, Mr. Counsel, he is not doing that. He said that the reports have been submitted. Why are you not taking a final call?
That is not the prayer, not.
Be that as it may.
It is for setting aside the suspension.
Be that as it may. That is what he submitted. ABC. G. Where is G? G is. He is under the against the suspension order.
6 to suspension. Lord.
Huh?
6 to suspension. Only criteria 48 hours of detention. If it is not there, Lordship.
Mr. Nayak, I have given you a break. 3 weeks. Do what is required, come back.
Right. Okay.
Do what is required and come back. Because what the procedure that you are following is not correct.
Yes, that is there.
Then, Ms. Kurogi, explain it. Do whatever you want to do. Come back. Let's see what they do.
May I pray for some early death, my lord?
No. With the nature of your allegation, maybe wrong.
Let them file their inquiry report, my lord, along with the.
She'll produce it.
They have not filed.
She'll produce it. Let's see how it goes.
I'm hanging, my lord. And
We'll
lack of
consider.
retirement also.
We'll consider. On the next date, we'll consider.
May please lordship. Had been suspension with effect from 4/4/2024 lordship.
Lordship, I have provided lordship.
No charge sheet filed. Heard Ms. Tiso, Learned Counsel for the petition. No department proceedings?
No.
Heard Ms. Tiso, Learned Counsel for the petition, and also heard Mr. Ms. MS M. Bhattaji, Learned Counsel for the.
Lordship, we are not made party lordship.
Okay.
But we have been.
Okay. Heard Mr. P. Nayak, Learned Counsel for the Standing Counsel PWD, appearing for the respondents number 1, 2, and 3. So the grievance raised in the present petition is pertaining to order dated 17/11/2022, by which the petitioner was placed under suspension in pursuance to her detention in a criminal case so instituted against her. So as projected in the writ petition, the petitioner herein, while serving as a junior engineer, bracketed C, Public Works, Road Division, Bojali Territorial Roads Division, came to be placed in detention in connection with Baihata Sareli PS case number 218 of 2022, under section 379/411 of the IPC. Full stop. With on 17/11/2022. Full stop. It is contended that the petitioner hearing was full stop. Petitioner thereafter was enlarged on bail by a bail by
30/11/2020.
Messom bail is by the trial court.
No,
No, High Court. By this court, wide order dated 30/11/2022. So passed in bail application number 3186/2022. So it is contended that the petitioner on being enlarged on bail had proceeded to join his services on 2/12/2022. However, 2/12/2022. Also, the petitioner thereafter continued to discharge his duties. Also, however, on 4/4/2024, the petitioner 4/4/2024, the petitioner came to be placed under suspension. However, wide notification dated 4/4/2024, the petitioner came to be placed under suspension. And therein it was intimated that the petitioner had failed to inform his superior officer of his arrest, which is regarded as suppression of material information. Also, the order dated 4/4/2024 continues to hold the field, and the petitioner accordingly, the petitioner is under suspension till this very day. It is brought on record that the petitioner had approached the respondent authorities by way of filing representations, praying for revocation of the order of suspension. However, the said order of suspension continues to hold the field, and the respondent authorities have not considered as to whether further continuation of the petitioner under suspension would be mandated in terms of the representations as submitted by him in the matter. Full stop. In view, full stop. Paused with the above factual matrix, this court had requested Ms. M. Bachaji, learned additional senior government advocate, Assam, to receive instructions as to whether a charge sheet has been filed in Baihata Chareli PS case number 218/2022. Today, Ms. Bachaji has placed before this court the instructions received by her in the matter, which reveals from the Superintendent of Police, which reveals that the charge sheet in the said matter has not been so filed till date. Full stop. The above being the position and the petitioner having been so placed under suspension, while the order dated 10/4/2024 and the period of 90 days having already expired, and the petitioner having also been bailed, having been enlarged by bail by this court, this court is of the considered view that further continuance of the order dated 4/4/2024 would not be called for, and accordingly, the petitioner is directed to be reinstated in his service. However, on such a reinstatement, the petitioner he posted to a post wherein, other than the post from where he was placed under suspension and placed under detention and thereafter under suspension, and he be so posted against in terms last paragraph to para 21 disposed of.
I'm deeply obliged.
Any urgent matters?
Mayor, please, on a time may be granted to file impleading petition matter. Respondent already transferred to another.
Any urgent matters?
Correction.
Huh?
Correction of
70?
74.
Yes, give me. What is the correction?
74.
This is some.
Look at the MSC.
What happened?
Paragraph, lordship page 11. in the middle paragraph. Yeah.
Paragraph 11, yes. Page 11.
Out of the amount of rupees so and so, an amount of rupees 2 lakh shall be released.
Where are
to
you
the
reading?
Claimant number
Out
3.
of the amount of so and so, an amount of shall be released to the claimant number 3.
It should be claimant number 2. And 2 should be 3. Because 3 is the minor lordship. Claimant number 3 is the minor.
Gyasuddin is minor.
Minor. 3 is minor. And claimant number 2 is the mother of the deceased. Just number of
Who
the,
is Asmina Khatun? His
she is the wife of the deceased. And only just claimant number 2 should be 3 and 3 should be 1. 2.
claimant number 1 is Asmina Khatun.
Yes.
That is the mother.
Mother.
2 is Sona Bhanu.
Mother of the deceased.
Deceased. And 3 is Ismail Hussain.
He is the minor son of the deceased.
Okay. What will we pass?
And another mistake is there, lordship. In the post title in my petition, appeal as well as other petitions are lordship correctly mentioned. But in the order lordship uploaded, your lordship will kindly come to page 8. Except appeal number 1, 2 and 3 different name has come. And
Oh,
so different. Post title lordship, perhaps lordship CIS, they have committed some mistake lordship.
No, because
But in the IA, that has been correctly given.
a cost title too. Gina make, Clarish make it to nahi.
That has come from other, perhaps from other petitions.
তুমি কইছ না এটা তো আবার নিজে বলে এটা কিন্তু আমার অর্ডার টুট নাই